Hi. Hello. 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 Ooh, it feels like I haven't been up here for a long time. Hi, hi, hi. Hi, what's up? Hello. Happy Thirsty Thursday. Hello, can you guys see me and hear me okay? Hi. I've missed being live. What is up? Let me see who's in here already. I saw Patty became a member. Shout out to you, Patty. Yay! I've missed you guys too. I've been so busy. Your girl is a robot lately. Yeah. So, yeah, I've been working long shifts. I'm in the healthcare field, so it gets crazy there sometimes with the long hours. I've been working like 12 to 14-hour days. Let me say hi to everyone. Hello. I saw us saying hi, everyone. Tipsy, Pantera, Witch, Patty. Patty, thank you for becoming a member again. I appreciate it. I appreciate you supporting. Yay! I know I see that, Patty. I see that. Yay! Yeah, your girl has been working. So don't come for me. I promise I will get back on my schedule sometime soon. Um, but yeah, I've just been working. I do have a lot I want to talk about. I'm late on some things like Karen Reed case. What is going on? Thank you, Patty. Yeah, cheers. Yes, it's like today's live is like a 50 after dark, 50% after dark, 50% true crime. We're going to cover Karen Reed, the motions hearing. I think opening statements. It's set to start on the 22nd, if I heard right. I haven't watched this, so we're going to watch it together. Do you believe Karen Reed is free? Hi, welcome everyone. I always forget to introduce myself. For the new viewers, hello, my name is Melly. We cover all things true crime, all things good times. We like to have a good time here. So if you don't like it, sorry. If you love it, we'll have you. Okay, so back to Karen Reed. Who thinks Karen Reed is innocent? Is she innocent? And what do you think about the new trial? Trial number 2. I'm shook. Yes, I do have a buzz ball. It's just not, it's in I put it in a glass cup. But yeah, it's that kind of night. So we're just going to watch the motions hearing, have a good time. Stay respectful, please. Stay cool, stay chill. We're just here for a good time. I have not seen this. So if you haven't either, we're watching it together for the first time. And I'm always down for that. So hello, Irony. Hello. Yay! Yay! Natasha, been wondering where you've been. I was just telling everyone, I'm like giving everyone the tea. Well, not tea yet, but I've been working. I work in the healthcare field, so I've been working like 12 to 14-hour shifts. And I've been going in on the weekends, which I generally don't work on the weekends. And so I'm just racking up that money, but I miss my true crime. So I need to like come back into my Mellyverse, get back on the groove. There's a lot of things. There's a lot of lives I have ready to go. I just been working so much. So shout out to all my healthcare field workers, all of you working them long hour shifts. It's tough. It's just a project I'm working on at work right now. So it's not forever, it's temporary, but I miss you guys. Thank you for being here and still supporting my channel, being a member, being a chatter, all of it. Glad to see you here, Natasha. And hello, Irony. And I said hello to BC Girl. BC Girl, I've missed you so much. Thanks for being here. It's brutal. I know you know what I'm talking about. Hello, everyone. Thank you for being here. So we're going to cover the Karen Reed motions hearing. Let me know what you guys think about Karen Reed too in the case. Let's get started. I haven't watched this, so we're going to have to skip through the breaks. Sorry, I don't know beforehand.
Justice of the Norfolk Superior Court and for the County of Norfolk.
Hey, Jules.
Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Hi,
Judge 22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
I can't believe we're at trial 2. I watched this first trial with Melanie Little on her channel, and this trial brings up a lot of things for me. Just the community and like the stuff I had going on then, and it was around the time I created my channel, and then Karen Reed itself is controversial case. I hope there's justice, but I feel like justice for Officer John O'Keefe has been tainted with all of this. I mean, how much controversy in media and etc. on Karen Reed. So it kind of sucks. But also, what do I think about Karen Reed? Yeah. What do you think? You tell me first. Hello, Abuelita Junior. I don't know if you heard me. Is she innocent? Is she guilty? Okay, let's get started. Not watch this.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for the Commonwealth. Good morning, Your
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good
Reed.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
I love
morning, Mr.
Yannetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists
Wow.
on what we all thought were still
Judge.
either under
Yes, have a buzz-
advisement or needed to be heard today. There's one that it seemed that,
I'm having a buzz ball. It's just on a glass cup.
all right, we'll start, first of all, let's start
That was my
with
week.
the defendant's renewed motion that is not in writing. I think Ms.
Why is she still a judge? I have no
Little,
idea.
I think this was
on
your motion
case.
for a forensically sound copy. You wanted to be heard on that?
Yes, Your
He
Honor.
does have a great
You did
team.
not file anything new, right?
I love Yannetti and Jackson. I really do.
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
They are?
Your Honor, the
Why?
defense respectfully
Wait,
requests
Patty,
that
why
this
aren't
court
you-
reconsider the
why aren't you
portion
running?
of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically
Are you on
sound
another
copy
account
of
or
the
something?
Sallyport video surveillance footage from January 29th, 2022.
I can't stand
The
any
court
of them.
obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth
She's nervous. I can feel it.
engaged in the protocol that they
I would be
proposed,
too.
namely simply
case is
dragging and dropping
wild.
files from the Canton Police.
I actually agree with you on this, Natasha. By the way, we're watching and reacting and talking. So the disrespect towards Don O'Keefe, the actual victim. Yeah, I know. Yasin, I come with love. No, this case, yeah, justice for Officer John O'Keefe. It's so sad.
Department computer onto
It's
a USB
crazy.
drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data. is
Dirty
not being
Canton.
published.
Dirty,
The import of
dirty.
this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th.
Natasha.
That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly
Love
imaged
you,
for our
sir.
review.
Okay, thank you, Mr. Brennan.
Tell me what you think. Is she guilty? Is she innocent?
It
How do you
seems
guys
the
feel?
defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed, and then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert
What do we think? Is she going to be guilty or not guilty at the next trial?
and download any
Oh
of the detective
no,
file and
everyone's
see
going to
what
go
exists,
crazy.
they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're
So much
welcome to come
corruption,
anytime.
right, BC girl? I agree.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been in our request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you
What?
ask the question to me. Answer it, Mr. Brennan.
The defense
Tell Judge Bev, tell Auntie Bev to take it down a notch, just like 1.1%. Like even that will help. Just like take it down a notch.
cannot download the entire detective file because
Number
it
seven.
contains files wholly unrelated to this
Not a
case.
fan.
And it would
Not a fan.
then intrude upon private information and other investigations. They can go to the detective file and they can download
He needs to have a bug
everything
ball.
to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the
With the
next
new jurors,
motion
now it's a
we're going
reach
to do is just the motion for the,
Good question, which I think yes, they have to know it's a retrial, right? That's a good question. Never thought about that. I'm gonna look it up.
view. I had asked defense counsel to propose something about how Ms. Reed will get there.
Hey,
Have the two
Francis,
of
good to
talked
see you,
at
love.
all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view, she can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously, the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were we were not on the same bus as the jurors.
Yes, we were.
We're just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better
What?
the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which,
Oh, they're riding on a bus?
and Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors.
I agree, Patty. There's a lot of cases.
Able to observe the same circumstance that we observed last
Thank you,
time.
Kristen. Appreciate you.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed,
That's
and
fine.
the rest will be on the bus.
That's fine.
I do
Thank you,
need you to
Chris.
talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the
Yay,
address.
DC girl.
The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they
They
decide,
want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel
The
talk
view?
about this anymore?
The view. What does that mean? Is that like the bus or something? What's going on? I'm lost. Someone please help. Hey, Debbie, good to see you. So they're talking about riding on the bus together. I didn't need it. Oh, look at her dad. It's her dad. And being nosy. Wait, why can't I hear anything? Did I pause that? No, I didn't. Can you guys hear anything? I'm like wondering if that's just me or what. Or are they oh yeah, maybe they were sidebarring. There we go. Nope. I don't know if they got quiet or if they were on I think it paused for a while.
All right, so on the defendant's list, I don't understand the
Bye,
motion
bye.
regarding Dr. Welcher, because that's been decided.
being
So
nosy. I'm
why
like,
is
I wanna
that
hear
here on
everything
this
they're
list?
saying.
Is it erroneously on the list?
Yay!
It's not erroneously, Your Honor.
Hello, my
but,
love. Hi, Kay.
Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr.
Thank
Brennan
you. Thank
is
you.
going to state it.
For being a member.
And that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slides? So
Why
I
is
know
she
what it
so
is.
rude?
Okay,
I will do that.
all right, thank
Thank
you.
you, Your Honor.
Why is she rude?
Okay, so Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
Is it? That's weird.
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to
Dog
ask
bite.
for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns.
Who thinks it was a dog bite? Who think it was Jen McCabe and the Alberts? Who thinks it was Karen Reed?
About the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing,
I think that too.
I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor rep parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right,
Okay.
that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily
It was
experienced.
not.
You will see that in his
Isn't it
report.
a canine dog?
The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian,
yeah,
some call them pet
canine.
dogs.
You know what I meant, German
He
Shepherd.
has
It just came
extraordinary
to my brain.
experience with wound recognition. Attorney Brennan respectfully is incorrect
Pretty
when
sure
he
that was-
says he doesn't have experience
Chloe.
with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites
being
two
bad tonight.
specific studies for
Who
his
cares?
report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling
we love
on
you, Molly.
Dr. Crosby.
You loving the
that
Mellyverse.
a
This girl.
non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby and understanding the court's schedule and other matters. Given that there was not an ability to have that motion determined, we then decided that we had to submit the report of
Debbie.
Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th
Y'all better stop giving
order
them
of the
eyes.
court with regard to Dr. Crosby. The
This
aspects
Patty.
of behavior in combination with a
I hope you
wound
have your balls.
recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach
Patty.
of Lieutenant Wing and his qualifications
Oh no.
exceed
Oh my gosh, I panicked.
that
What?
of
Hold
Dr.
on.
Crosby.
Why is it skipping?
Crosby.
Go ahead.
And my request, Your Honor, is
I'm like, is that my connection or is that the
Is-
video?
I do not believe there is a
I've read it many times.
Academy of Science report.
I'm about to freak out.
I'm
this.
I need to
The
hear everything.
timing of this report came in light of the court's ruling on Dr.
Not
Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby and understanding the court's schedule and other matters. Given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that
Okay, it's definitely
of
not me.
Dr. Crosby.
It's Port TV.
And my request,
The spacing
Port TV is
itself
doing me dirty.
is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a
Someone tell
specific
Vinny to get
and
his shit
substantive
together.
basis to
Vinny, that's
draw
why I
a
didn't want to monster
conclusion
anymore. You need
that
to
there
get your
is
shit together.
no way to a degree of certainty
Thank you,
that
Theory.
these wounds were caused by Chloe's mouth.
Thank you, thank you, thank you.
In particular,
Mallory
Dr. Russell had
Peters, welcome
opined
to
not only
Melrose.
that the bites were consistent with a dog wound, but she also opined
Thank you,
about
Kay.
molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
Were those dog bites or scratches, or were they not? I don't feel like that's the car.
thank you, Your Honor. I can go through this quickly. The National
Thank you.
Academy of
Appreciate
Science
you.
2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to
Thank you,
discuss it is you
beauty
have to
girl
have the mold
and
and the
Kate.
overlay. Dr. Crosby doesn't have the overlay. So even
Easy girl is
not considering the first point I made, where that's allowed for
BC girl
humans,
and
you need a
Louise.
mold and an
giving away
overlay.
memberships.
So
Thank you.
there is no
I love
basis
you both. I
in
appreciate
science
you.
for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction
Welcome
that
on
Mr.
the
Brennan tries
numbers.
to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion.
Kay and Patty, all supporters. I appreciate you. Thank you so much. Really does help your girl out and me channel. Just a little family here. Little family. Little wild family. Very much so. Little buzzball family.
In an exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should
My
be no
buzzball's in here tonight.
discussion with regard to Chloe
I
on
needed it chill.
inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
And I'm not like no Amazon promoter or anything, but like get these cups right now. We're doing like a little like video haul, like no, but really, they're glass. You can put them in the freezer. They're great. Not a little Amazon storefront promotion.
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires
actually
third-party
really
culprit.
expensive.
And so before there could even be discussion
All
about
on a
that,
budget, baby.
there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right. Thank you.
Someone tell Aunt Bev
The
she needs a drink.
substitute chemist,
Above
is
all.
there any objection to the substitute chemist?
Hello,
Commonwealth's
my
motion
love. Hello, prison
663.
guard.
No, Your Honor.
Okay, so Jim, 63 is allowed.
Yes, Your Honor.
We are getting it tonight.
You both have motions that are similar
Oh,
regarding.
we're getting it tonight. Your girl's been working a lot, which is why I haven't been live. I know I'm slacking. Don't come for me. We already talked about this at the beginning. Let's get the conversation out of the way. Yes, I haven't been live as consistently. I've been working 14-hour shifts. Don't worry. I'm still here. You have not got rid of me. Wishful thinking. Nope. No, but I have tons of lives already ready to go. There's not enough time in the day. There's not enough time in the day I have to go to work, YouTube, true crime, gym, cook, talk to my friends,
It's the
drink a ton of Buzzball.
Commonwealth 669 and Defense
We haven't had any
670, I
Buzzballs this
believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
I can't wait for this trial.
The Commonwealth agrees to give notice. We've provided a number of clips of
We're going to be streaming it. I don't care if you have to pull all-nighters, bring your little blanket, bring your little babies, bring your little drinks, whatever you need to bring.
statements that we seek to use during the trial.
Bring it on.
I hope to narrow
Mallory,
the ones that
welcome.
we're going to use specifically so the defense can
membership.
have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense.
Now
If
tell
not,
her
we'll
to
do
put
that
me in his
shortly after
movie.
the hearing.
I need to be in a movie
Okay.
for Prison Guard.
Who's arguing this for the defense, or
who's here
who's
looking-
telling me what's
Hi,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to
Little
use
babies.
as soon as
Little
today.
balls.
All right,
Bring your
I'd
little
like to
balls.
see what you both intend to use in your openings, because
Buzzballs, I mean.
whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
This is a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay,
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the
Oh,
court so
thank
you
you,
can
guys.
have an opportunity to view if you wanted to.
thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've
Mhm.
clipped the pieces
Yeah.
that we
Whose
want.
sugar mama am I going to
It's
be?
been an ongoing
Ah,
process. I
just
understand
kidding.
my office has sent a slew of those clips to the defense.
Okay,
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to
What?
provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a
Wow.
look at that. Okay, so that sort of also covers, I guess,
Oh,
the defendants, I'm sorry, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
Yeah,
No,
basically
you're
it is.
Okay,
I know you work in healthcare
Can I
too.
make a note?
yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay,
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
all right. How are you going to find this?
This is Karen Reed motion hearing before her trial starts on 22nd. Correct me if I'm wrong.
But we could have somebody playing close from
Karen
state police,
Reed.
or we could find somebody that's agreeable to the defense, but I think it would be best if we.
The
have
one who
an independent
allegedly
reader
hit her
throughout the
boyfriend,
trial
the officer.
to play that role.
Okay,
Alleged.
yes.
I know there's like mixed emotions too, because like we hear the phone calls when they're being angry with each other. We know there's like a level of toxicity. Everybody was drinking it that night, but every cop in Canton drinks. So what does it matter? And then there's the whole like jealousy thing with the females. That's a whole nother thing too. And just the corruption in Canton. So I don't, I have my opinions about specific things. I know some of you know how I feel. I do think she is innocent to an extent. I also think the Alberts played a big role into it. I will say that. It's my channel. I can say what I want. I think the Alberts are guilty of something. I do think Officer John O'Keefe got beat up. I think that's for facts, whether it was whoever beat him up, whether it was a dog, whether it was a man. The whole getting rid of the dog, the house, the cell phones, the jealousy, the girls on the trip. Like, if you've really followed the case, there's a lot behind it. But, maybe she did. Maybe she was just a crazy, raging, drunk girlfriend and backed up into her man and hit him. I don't know. There's many. I'm not saying that's what happened. I'm just saying these are what the options, right? The theories. I think it's taken over. It's overclouded the justice for Officer John O'Keefe. But I do also think it's an important case because it is pointing out how the law enforcement system works and corruption and police departments and power for people, right? Oh no.
Facing its.
Don't hate me, but I think I fast forward.
Thank you.
We have.
Comment was in the beginning, and
Let me know if we've already seen this part because I don't remember.
Between inclusion and exclusion, between inclusion and
That's where
exclusion,
we
the
left off.
National Academy of Forensic
She
Science
definitely gives
is
off crazy.
extraordinary
Really?
well respected.
Wait, is this where we were at?
Times,
I can't stand when I do that on YouTube.
and that is a consensus among experts that teeth structure can in many
It's
ways be
definitely crazy.
similar. So it is unfair to conclude that a particular person or a particular dog
What's the vibe?
should be included or identified as the person who
Wow.
left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen
Karen Reed.
to exclude a person or a dog as the contributor of that bite. In here,
A
there
lot,
is
but too much
definitive
isn't about that.
evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those
Bo.
wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring.
They were both talking.
The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were
thank you,
caused
Missy
by
girl.
Chloe's
Yeah.
mouth. Particular.
What? Don't even get me started. Don't get me started tonight. All her groupies don't seem to think her smugness. I do think that's a thing too. I do. And desire to be seen as embarrassing, guilty or not. She isn't likable at all, in my opinion. And people watch some of those interview clips. Like, what was it? That show that she did like a 15-minute interview. And people thought she was really like conceited. I haven't really seen it yet. Jessica agrees. Hello. Those interviews. Oh yeah, I just saw Natasha post about the interviews. Bro, Debbie.
Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the
Most
mouth.
definitely turned into Amelia.
And since the defense
she seems stuck
has
up.
decided to
Wait.
identify particular
Don't
teeth
get me
and
started
structures
on people looking how they look and whether they're stuck up or not. That dude's face, bro. Who? I'm not a fan of the man speaking. I don't know. I haven't looked into him much. What's his? Oh, Brennan.
as the basis to say it's comparable, consistent with a dog. We should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
Do people like
Thank you, Your Honor. I
Brennan?
can go through this quickly. The National Academy of Science, the
What does
2009
checkup look
report
like?
Your Honor is referring to,
I don't think so.
there is no finding in
I
that
think
that
Karen Reed's actually really pretty.
exclusion's okay, but
And I think she can
inclusion
be
is not. There's
arrogant.
nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition.
Well, if the Alberts wouldn't have got rid of Chloe, we maybe would have had Chloe and there would be no molds necessary. They would have just been able to use Chloe in her teeth, right? Question mark.
Position that with certainty this could not be
Hey,
Chloe.
Fernando.
So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's question, comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
Okay, Natasha. You're fired
I
up.
simply suggest
Whoa.
that there is no authority that I'm
I like
aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe,
Wait, someone said, Pantera said, I'm pretty sure she's nuts. Pretty sure she's nuts on based on what? Just because she's a girl and she was drinking? And we heard her acting crazy in a voicemail. But if you knew you were on breaking terms with a partner and that they were seeing or quote unquote seeing or talking to other people, wouldn't you be acting the same? My life, chill out. Chill out before I time you out. What is like, we can have a whole ass conversation about this. Nope, but because everyone is at least a little nuts. Wouldn't you be screaming on the phone too if you knew your partner was cheating on you or whatever was going on or breaking up? I feel like we've all kind of been there. Don't lie.
as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim 63 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's
I feel like as much as we think that maybe it wasn't Karen Reed, or maybe it was, I'm leaning towards more they might find her guilty. I'm not being a hater. I'm just, that's my theory.
about the audio visual aides and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done
I
so
hope
with
not,
regard to
but-
openings?
Because I think there's a lot of corruption, but
The Commonwealth agrees to give notice. We've provided a number
I
of
don't
clips
necessarily
of
believe that, but
statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's
I am,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio
Wow.
clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the
I just
defense,
can't with
what you
Judge
intend
Bev.
to put up?
This is a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay,
Your Honor, I'll add that there are a number of statements that we have clipped.
the Commonwealth
We,
had a
with the
years for
court's permission, would like
discovering.
to provide an entire package
Right,
to
Pat
the
Randall.
court so you can have an opportunity to view if you wanted to.
thank you.
That's true.
So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process.
Mallory doesn't know we have an emoji that says "Don't come for me." Mallory says, "Don't come at me." And if the people in the house are highly involved and there's a fight, how would they know that Karen was blackout drunk and wouldn't remember anything? It's legit. We welcome all opinions. Let me go back and read that. And wouldn't remember. I think they selectively remember what they want to remember. Like when the Albert, he's like, "Oh, I was sleeping up in my bedroom, didn't hear anything," and there's like police and like firefighters. I don't buy that. I don't buy that. I don't know. I don't know. I'm thinking about the case.
And my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion.
I don't know what I
want to narrow
think.
it down. We've given them.
I don't know what I think.
Inclusive of what we intend to.
I'm stuck.
provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I
do
think
think
that's
you
what they
do.
just said. They're just going to
yes,
give
we'll
you.
give
I will
them the file
stick to
name,
that.
and
I'll
if
stick
the court
to my
takes a
opinion.
recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a look at that.
Go out.
Okay, so that sort of also covers, I guess, the the Commonwealth's motion regarding the use of
He did say I hit him. I hit him.
extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay,
Can I make a note?
yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay,
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
all right. How are you going to find this person?
But we could have somebody playing clothes from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay,
May I have a moment, Your Honor?
yes.
I feel like this trial is going to be so insane.
Having them read,
Oh,
I don't see,
oh my gosh.
but to have
My boyfriend Alan Josh.
And the defense and the defendant, there is no author of those. And so we will introduce those if we have an independent reader who's
Wait, let me go back. All the locker talk, and they wanted him. I can see that, number 7. Her smashing into her boyfriend is what killed them. That'll prove her guilt. Off the hook trial, even Fox News. Wait, so Kat Randall, you think she's going to be guilty or innocent?
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended
I
to
don't know. I think it could go
independently
both
read.
ways at this piece.
At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent
Appreciate
reader is going
you. And we've missed
like,
you. I'm glad
I
you're
can't
back.
really weigh in.
Or having a break from work.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe
Yeah,
and
we've
the
missed you,
defendant,
DC girl.
there is no author of those.
Everyone
And so
tell me I
we will
haven't followed the
introduce
case much.
those
Just
text messages, the
innocent.
admissible ones, at different parts in the trial when they
I agree.
become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case. To bring him back regularly as a
Super
police
Garino.
officer, I think is creates the wrong impression. I think objectively, we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Garino is the one who found it,
The vehicle did not
found the
strike
text messages,
Officer
he was the
John
one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have
Paid by the state. Remember, the people they hire, they're paid. Regardless, those text messages were nasty. Nasty from Pooper Proctor.
somebody else come in or other individuals come in to act as
I don't.
leaders,
The wounds, y'all.
it is not in keeping.
Didn't he have like broken like black eyes? How would the car give him black eyes unless the car like hit his face or his face hit the car? I don't buy that part. I just don't.
The ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater
Many things could be
to
true.
the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
What?
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed.
Nope.
The text messages
That's
speak
right.
for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between two independent people.
I agree with this.
Motives that may or may not be consistent with the text messages. As we
I
all
agree.
know, it's a very,
That's
very
fair.
different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly
Hey, smart dog.
objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Thank you. All right, defendant's motion for specific discovery, paper 638, Jimmy. All right, who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard
That
to
is true,
request
Natasha.
number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where? Where in Rule 14 or the reporter's notes?
Relevant,
Wow.
and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay, I'll hear from the Commonwealth.
Oh, number 5? Yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Wait.
Okay.
What?
Mr. Brennan,
Reward?
regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness. If they had any reluctance or concerns about testifying, I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right,
I think Bev likes
the
the
ARCA
attention
witnesses.
he's getting.
Motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense
I
back from its
do.
inception.
I do buy the witnesses, the ARCA, the what do they call him? I thought he was kind of cute, actually. The ARCA
It
guy.
is important because that information,
What do they
thorough
use to
vetting of
call
the
him?
information, may be a basis for the Commonwealth
I forget his
to
nickname.
inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure.
Oh, Crash Daddy.
And so while we've received
Crash
some
Daddy expert.
answers to our questions, we want a full vetting of that history.
Don't come for me. I didn't make it
On a
up.
prior date, the court suggested that perhaps we could have a voir dire,
He's-
not regarding their qualifications, but regarding this very issue about the relationship
Full
between
of
the
spice.
witnesses and the defense. That is
Chill out.
one viable option.
Don't come
My
for me.
concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination.
I'll see you soon.
And so if the court was to
I'm a
maintain there
man.
would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are
Trial
ordered.
starts next week,
So
right?
if the defense
Can we check
position
those
is
out
not
next
in their
week?
custody and control,
Yeah.
and then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in
Next
the
Tuesday.
notice from the defense, there is some suggestion
Crazy.
about the ARCA witnesses potentially rebutting or
I
commenting
won't be able to stream it
on
live, but I want to watch
Mr.
it
Welch's
definitely.
testimony. Discovery deadlines have passed some time ago. It would be
You guys gonna
inappropriate
watch
at
it
this
without
point
me?
to have any
Oh,
new
watch it without
opinions,
me.
any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to their February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA
I've
limited
never had an
to
Android in my life.
the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Oh. Alan Jackson's going up.
I want to go in reverse order briefly, if I could, concerning the
He's like,
the discovery deadlines. We
Sure.
have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their
which
notice of
one, Cat
completion,
Randall? Are you talking about the
or certificate of completion
Sandra case?
long ago, and we have consistently received new information from
Sandra
their
Birchmore?
experts, new reports,
I've covered that
amended
here before.
reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate there too.
I'm so glad she has the same.
And insofar as, or to the extent that any additional testing and or analysis is
I think they were
completed
gonna let her do
by
it.
those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
Why does she interrupt them? Like,
Ballpark are you talking?
When I get a
I
report,
can't.
will turn it
When
over the
judges
same
do
day.
that,
If I get a report, I will turn it over the same day.
Like,
If I get a new analysis, I will
let
turn
him
it over
finish.
the same day. If we get
How
new
does that
testing
bring you
results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once they get it, we'll turn it over. That's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So.
okay, regardless of whether
This
we
is not
think she's
unusual.
guilty or innocent, we know it's kind of like the Delphi case. The investigation is tainted. There is corruption. They did mess up. We can at least come to that conclusion, right? Something was off. Whether we think Karen's guilty or not, then yeah, we can think whatever we want. But evidence in red Solo cups, the car, the one strand of hair. There's a lot I don't buy, but I'm not saying that makes her innocent, and I'm not saying that it makes her guilty either. I think I guess I don't know how I feel. There's numerous factors that play a role in like my perspective and what I think of the case. I do definitely think there's some type of corruption. I do definitely think they were in a toxic relationship. I could see her doing it on accident. I could see her doing it on purpose, but I could also see him being beat up. I could also see the Alberts doing something. We talked about the trip in Aruba, other females being involved. One of my theories was that some of the females that were friends, or knew Karen Reed because they weren't necessarily friends, maybe had a thing for Officer John O'Keefe. Why not? Allegedly he was a nice guy in this group of cops, right? Or no? When you listen to the voicemails, that's very much opinion based, and our psyche, I think we jump to an opinion because we have been through similar things, whether it's being in a toxic relationship, an abusive relationship, like we recognize. So I think it's easy for us to like think right off the bat, okay, yeah, they were being disgusting in voicemails, guilty, or like he was abusive, she was abusive, or like they were toxic, or I think it's easy to jump to that conclusion. I hope I'm not rambling, but like I feel like sometimes we got to take like our own experience and perspective out of that and look at it from the outside. So I do think it was very toxic. I do think those voicemails play a role, but I don't think necessarily they should play an ultimate role. He's not here to tell his side of the story. Those are just text messages. Nobody was in that relationship other than them. We were not in that relationship with them. So we're only going based off of voicemails. So that's how I feel about that whole part of the situation. And thank you, Natasha, for gifting. Yay! Thank you, thank you, thank you. All the gifters today. Welcome to Mellyverse. Jojo, you got a membership. Jay Warren. Shout out to Natasha, BC Girl. All of you who've gifted. Kay. Where'd Kay go?
A party says
Cat
we asked for all
Randall.
13. Another
Yay!
party says we gave them to you. And then
Thank
the
you,
party
guys.
says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes.
Thank you.
Their response is that it's not.
Ramble on.
So for which
Thank you,
ones?
thank you,
Which
Natasha.
of your numbers?
Thank you for being a mod too.
Number one, a complete statement of
Cat
all
Randall.
opinions to be expressed by Daniel
Yeah.
Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline
I was
has
rambling.
passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation.
Thank you,
This is
Cat Randall, for
exactly what I was worried about.
A lot of new Mellyverse members. Did someone give them a little warning? Like, comes with the balls, the buzz balls. No, but welcome all new members to Mellyverse. Shout out to Cat Randall who just gifted. TNBN, welcome to Mellyverse. Why are you saying ooh?
Back in November, what I expected might happen and should
Oh,
not have
who's that?
happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all the
I just had a red
communication,
one,
all the
but
text
I have
messages,
two
all the
blue ones.
emails between the parties.
My fridge.
And if the defense's
I have to work
position is not
tomorrow,
in their custody
whatever.
control, well, it's certainly in the custody
Life is too
control of
short.
ARCA. We do not have. all
Caution,
fire
enter
reports,
your
all
list.
fire testing, all film, photographs, pictures. We don't even know who was what part of this report.
I love that.
Okay.
And so my tolerance
Make emoji.
about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
The
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent.
The blue one is blue
Arca
raz.
testifying.
This one is
Let's just call
strawberry
it like it
Rita.
is. They
So
desperately
address
does
number
not
one,
want it.
please.
I
Okay.
am. That's what I'm doing, Your Honor. We have provided.
Someone tell Bev to stop interrupting. I can't stand that, especially coming from a judge. Like, I think someone in that position needs to learn to listen and just like let people finish their sentence, especially at a hearing. Like, I guess it happens all the time, but I'm just super sensitive to it. I'm just like, it's so rude. I don't know. Just let them finish their thought and what they're saying. I don't know. Am I being petty? Are we at Petty University tonight?
Provided on April
Agreed. Patty agrees.
12th.
Very
About
clear line.
1,000
Yeah.
pages, additional pages,
Abracadabra. Suddenly this turns
responsive
to-
to the request specific to ARCA.
I like the green one.
The
Oh,
response that we
I can't do the green one.
provided to request number one is as follows. The information in the possession, custody, and control of the
rude.
defense has already been produced.
I don't
can
even
be
like when people
found
do that
in the ARCA report,
I'm like,
the
let me
voir dire
finish.
testimony, and the trial testimony
Ma'am.
of Dr. Wolf and Dr. Rentschler. That is specifically
It's
in
any
response
judge
to
that
request
interrupts,
number one. What we have,
It's just
they
rude.
have.
I think even in general
Mr.
conversation.
Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we
I mean, I'm not
have
perfect. I
not
do
turned
too.
over
But
that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried
this
about.
is a high
et cetera.
profile trial.
We could not engage these experts until we got permission.
threw up-
from
no,
the
no, I
Department
don't
of
like the
Justice.
flavor.
The federal government had to
The
give us
regular
permission.
ones, like the apple
They
one.
gave both sides permission on March 20.
The regs. I don't like the regs one. I don't know if I've had. He sounds like the poem is getting him. I don't know. I can't remember which green one is the one I don't like.
2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the
I think
defense
he's
in this
a really
case
good
in furtherance of
lawyer.
potential testimony moving forward. We do not have additional testing results. We do not have additional
Oh, it
analysis.
was.
We
It
do
is
not
one.
have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through.
Okay, do you guys want to know what I think will happen too? Is I think Karen will be found guilty and she's going to be like the female version of Wade Wilson. Like, I think she's going to get a bunch of fan mail and we're going to get her calls and it's going to be a whole thing. You can see that happening or no? I need another drink. I can totally see that happening.
The other
And like her being like a celebrity prison celebrity or whatever, where they do like interviews. She's on like 48 hours.
I have a question. It was my question.
Whatever
last
that guy
time
is that does that
testified.
interview that did Lori
It
Vallow
wasn't
interview.
clear to me
Morgan
who
Pierce,
did
like
what. Would each witness
be all up in there
did
interviewing her.
regarding
Yeah.
testing, preparation,
Yeah.
things that
Henry phone
are
calls.
normal cross-examination?
I
Is
feel
that
it coming.
clarified any better?
I feel it coming.
They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rentschler talked about what he did, which was more on the biological
I get
side.
there was a difference
Right.
between the
And
two.
Dr. Wolf talked about what he did
Someone
on
told
the
her to
cannabis
stop freaking
side.
interrupting.
They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well. But
Is there anything that they're going to say they cannot provide because of the federal investigation?
not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
I don't know. Karen has a lot of people supporting her too.
Right.
You know, this whole Karen
Ms. Lou
movement.
I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes, that is on. That's
Can
on the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely, that is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were,
I'm losing
that
my
is
sight.
confidential. And
Can I see Counsel at sidebar?
Oh my God. Sidebar means Melanie gets another drink. Is that what sidebar means? Okay. New meaning for sidebar. I don't know, Pantera. I think she's toxic, but I don't think she's, yeah. I think it wasn't just her. Could it have possibly been one of those situations where like maybe he got beat up? There was a party, people were jealous, there was a fight, the dog was involved. Maybe him and Karen were fighting. Maybe he walked out and was like, I'm throwing my phone at you. And like maybe he threw the phone or something. And then she like backed up in him on accident. Like maybe one of those things. You literally think he was just standing outside the house and she just and backed up into him? Or was his body already there by the time she got there? Maybe she was too drunk and didn't see him. Maybe she was just hella drunk. I feel like so many things could be true in this. I was all about her being innocent. It truly was until the HBO Max docuseries. Okay. I haven't seen that one. Every criminal has loonies that follow them. We're all human. We're all a little loony in some aspects. I have always believed there was a fight in the house. Good to see you, Stubbs. I believe that too. She would have reported that. I don't know. Would you have reported that if you were in this situation? I want to watch that too. Was this a mistrial originally? Yeah. It was a hung jury. What is the standard reasonable app? Oh my gosh, can we? If so, we're doing that tomorrow, Patty. I need to make sure, because Netflix, someone tell Netflix I got beef. We got beef. With the whole Gabby Petito thing, that was total bull. So I'm afraid to pay any Netflix because they go on here striking people who stream. I think they beat him up. I think that's for sure. Whether it was an accident, she didn't intentionally, maybe they didn't mean to kill him. You have to watch it. Okay. The DNA would have shown you, but didn't the DNA show that he was beat up? Those weren't car bites. He had black eyes. He had a fractured skull. That is pretty severe. I don't think that happened from her backing up into him. I don't know. One time my cousin was drunk and backed into someone, like in the parking lot. I don't know what speed. I can't remember what speed Karen was going, but the person just got knocked down. That was a long time ago. Don't come for me. I'm in for, movie night. Movie night. Bring your little onesie and your little popcorn. His entire arm was torn up from nothing. The black eyes. So did Karen Reed reverse into him and the tires hit his eyes, or like what? Because there was not a lot of damage to the car. His injuries do not match the incident. I agree. I kind of felt originally that she hit him for sure. Could it have been an accident? Now we have to Could it have been an accident? Maybe she was too drunk. They were fighting. Maybe he got beat up. Maybe he went outside and she didn't even know, and so she lied, and now it's this whole thing. Who knows? There's so many things. Don't come for me. I'm not saying she's guilty. I'm not saying she's innocent. I just think that many things can be true at once in this situation. I'm going to fast forward it. For some reason, they got us on silence. But I was over here rambling. Officer John O'Keefe was not struck by a vehicle. I don't believe that. Yeah, 100 stories for this one. And why get rid of I think those things playing, why get a new phone? Why rehome your dog? Are you rehoming your dog from one day to the next? Because if so, I have questions. Did you stop loving your dog? What happened? Because I sure as hell ain't rehoming nothing. Especially not my dog. Like, I'm ready to throw hands for my dog. Well, I had a little Chihuahua. Imagine. Why redo your house? Yeah, in the basement. I have a dog right now, but I kind of want one. But yeah, why redo your house? And then wait, he was it Albert? Was that Chris Albert? Is that his name? That was throwing the phone in the trash can. Wait, am I getting my true crime cases mixed up here? No, I'm pretty sure I'm not. Didn't he throw the phone in the trash in the bins at work or something? Or am I totally thinking some other case? So many things could have happened, right, Patty? Higgy. Oh, it was Higgins. Why am I getting them confused? Higgins is the one I don't like. That's the one, not the Albert. Higgins is the one that was texting Karen, and he was the one who wanted Karen. He wanted to bone her. He was in love with her, I think. Those text messages are crazy where he's like, oh, like, what are you going to do? Those were a little much for me from Higgy. I do think that was sus. If you plan to go to the store, Melanie, what does that have to do with you killing someone? The day, like, after the crime? I don't think I don't believe in coincidence.
All right, so Mr. Jackson, you're saying that the ACA witnesses did not do
I just
anything,
don't
did
believe
not
it.
read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti. And you
Why does
have
she
that
say it
all
like that?
documented, whatever information the ACRA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into effect.
When did it start?
I don't remember the
Oh
date.
my God.
September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office,
That
was
gets under my
receiving
skin.
information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA
Do you
to
know?
answer their questions.
Do you know what information was provided?
Yes, it's in the report. There are
All right,
14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a
What?
very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you
September of
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when
that's
did you
what we
do,
provided to them.
when did you do that?
I want to say March 26th or 27th. I think it's in the motion.
Shouldn't she know these dates?
Okay.
She's a judge. I don't know. Like,
Additional discovery for the experts for their review on March 26th, 2025. That same
so
day, the
annoyed
defense
with her.
provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the
regardless of whether
140-page,
Karen is innocent or guilty,
PowerPoint, etc.
that pissed
We
me
wanted
off.
them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh,
You
I
said-
didn't say 3 days. I said, I think we can count it in days, not
I mean,
weeks.
another
So
day.
I would expect if there is something that we're going to receive, it's probably in the next.
Can I
week
get
to 10
another
days,
drink or you guys
I
can
would
come to
guess.
me? Oh my God.
All right.
People are like, oh my God,
We're acting
millions of
as
drugs.
efficiently as we possibly can, but
No.
we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been
Oh.
concerned about since the beginning
Here we
of this
go with
case.
the
And I've made
theatrics.
every effort to alert the court that I had a concern. In fact, that I anticipated
Go, go,
this
go.
very
Okay.
thing would
Patty
happen.
says go, go, go.
When I began this case,
Don't leave.
beginning of October, end of
We'll butt
September,
down here.
my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARC from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds, it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witness.
I'm open to other people's opinions. If you forget all the extra stuff and focus on just the evidence, is there evidence of him being beat up, evidence of a dog bite? And even if both happen, it does not excuse being run over. We don't know if he got run over. The evidence also shows that the video was faulty, right? I think many things, like I said, can be true at once. The one strand of hair, I'll buy that.
Witnesses provided a
But you're
report
right.
that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time.
What about her ring video?
Then provide information to
It was
ARCA
deleted,
on the
right?
eve of opening statements. And then expect to come in with new opinions and information and reports
Who
after
deleted
we've
it?
already
though?
given an opening statement.
Karen
It's
Reed?
not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA
too,
to come
Kat.
back
Me
and
too.
potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery.
Wait, so they didn't want to let the ARCA guys testify? Is that what it was? That's crazy. I think they should definitely be able
Of
to.
the information that we want. That's what I asked this court to do.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander.
Wow.
Mr. Britton has
You
been
really use that?
consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Wow.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report.
So like,
there's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines January
Oh, I
31st,
thought they were talking about like the
2025.
original document.
And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines.
February
The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judd Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there is no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right, thank you. I think is the only thing left the motion to sequester Aiden Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
We're talking about Turtle Boy.
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to.
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct, which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial.
Ooh, I want
the Commonwealth was
stronger.
conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that.
Wow, that is shady.
All right, so I don't have a copy of what it is you intend to introduce, right?
Amanda.
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing.
Wait, are you guys talking about?
I need
I'm
this in
shook.
writing. I need a Commonwealth's response.
We needed to have a rule.
Oh my gosh, I'm shook. Who are you guys talking about? Alan Jackson's beard? Oh my god, I like.
Ruling on this in advance of.
Excuse me?
We need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
I feel like
All right,
we could get
give
in
it to me today,
trouble
I'll
up here
decide it
tonight.
tomorrow.
Okay. Are we allowed to make an oral argument
like
as to
that.
this issue? It has been briefed already by the Commonwealth.
Okay.
Yeah, it's going to be all over the
You
place.
know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as, it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway, so that you can look at the video to see whether there's an objection to the opening. So
Someone
why don't we
tell
take a
Bev-
15-minute recess?
Bev.
And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
I think Dad needs to chill out and have a buzzball with us. A minute. Has our break that long? Wow.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it.
This craze.
Okay.
This craze.
I was able to see the video.
Craze
Super.
Okay.
is
All right,
nuts.
were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection.
I'm on trial.
And I did
Ellie's on
also
trial.
provide, there's only a single photograph
no.
we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll
Mr.
hear
Shear,
you on
she's
this
sleeping.
motion.
Like a little
Um,
angel dinosaur.
Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in
See, don't come for me.
agreement on most of the issues.
Okay,
They have agreed that we are allowed to bring in the sustained
I'm
findings as they relate to Trooper Proctor, Trooper Buchnick,
Natasha's
Detective
like-
Lieutenant, and Detective Lieutenant Tully.
okay.
Natasha's like, I had a bad dream. What is your bad dream? Was it Karen Reed dream? Wait, I hope I didn't. Wait, what, Melly? Wait, did someone say tipsy? Oh, yeah, you did. No, I meant like she was sleeping. She's getting her little sleeps in. You know what I mean? Did the moose and the squirrel cause issues? Natasha, what was your nightmare? What was your dream? What was it?
The only issue that we need to work out, Your Honor,
Was it Karen Reed
is
related?
with regard to Kevin Albert. And so we will continue to discuss that. I'm not
No,
as
Tipsy's
concerned
getting
in
her
terms of
beauty
timing with
sleep.
that particular issue.
She needs
Okay.
If the court will give us, another day or two to discuss
tell
it.
me.
Sure.
Well, if there's a remaining issue, we can address that
Wait.
promptly with the court.
Oh, the
Okay,
little
Can
one.
we address, is it something you need for your opening?
Oh, I'm
Okay,
trying to
all right, so yes, we'll address it sometime
little
next Tuesday or
one. I was
Wednesday.
like-
Take your time in working it
I
out.
gave
All right.
Natasha back.
Thank you.
Okay, so now is the only thing
Maybe I should have
left,
buzzball.
the motion that Mr.
I
Brado's here
did.
for?
I was gonna.
As far as I know.
See,
Okay.
but the little had a bad
All
dream,
right.
not Natasha.
Morning, Mr.
I'm like,
Brado.
we had a bad dream about Auntie Beth or me.
Okay. So, Jim, you have that.
Yeah. The buzz balls come up.
I
How's
probably
you,
have it here,
Chrissy?
I have one, Jim, thanks. All right, I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you
Wanted
stay
to
right
save
there, Mr. Brado.
Natasha from her bad dream.
Mr. Brennan, you're asking for
Natasha.
sequestration on all the witnesses other than the ones that have already been decided, right?
I won't be surprised if it was you, girl. How
I'm
many
not
did
sure I
about
understand.
Bev?
So there was already an order
Auntie
on
Bev.
who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aiden Kearney be
You have to
sequestered?
members of
I
someone.
am. He's a named witness.
Okay. Does the Commonwealth intend to call him in
Oh,
your
boy.
case in chief?
I'm gone for 3
Depends
days
on
and
the
I come up
development
here
of
and
the
act
case. There are
crazy.
two issues that are important.
Well.
One in case in chief is
Welcome to
whether or not there's
Mellyverse.
any development of third-party culprit. If there is,
I'm not going to pretend to be
Kennedy
something I'm
becomes a more
not.
important witness, and we'll have to assess that as the case
Period.
progresses. The other is
I have a
rebuttal.
list of a whole bunch of channels to do
The
that.
defense calls the defendant to the stand, then it is strong likelihood.
Not
that
me
we
starting drama.
problems with Kennedy.
Oh,
Okay.
God.
Two things that I can't anticipate.
I'm
at this
good.
time.
Okay. All right, now I'll hear you, Mr. Bradle.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the
Who is
interest of time,
this?
and I think I know where the court's going with this,
You can't see with my
Uh,
glasses on.
based on the prosecutor's
I'm in
statements
trouble.
and the context. So with that
Oh, it's Bradle.
that
Okay.
understanding, Judge, I would just
I'm like,
start
I can't see
by
the
saying that,
bullshit.
there's really no reason to
Apple?
beat around the bush here, Your Honor. The Commonwealth is not going to
Wait,
call
Which
my
way?
client,
The
Mr.
buzz
Carney, who
ball.
for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the 5th?
At this
Yes,
point,
Judge,
Buzz
and I
Ball
just
is
should
behind
clarify
me.
for that.
Same with-
Okay.
That is under the government's, the
Hey, Frank.
obviously well-established position of Norfolk County law enforcement.
Natasha's
What we
amazing.
contend is a twisted
like,
interpretation
Nelly
of the witness
King, baby.
intimidation statute that seeking to contact witnesses, seeking
Oh,
to
boy.
question people is witness
Okay,
intimidation.
so just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your
You
Honor,
have to have a mood switch. I was
the
craving one today. It reminds me
the
of my
government is
childhood. I
seeking
don't know.
to first,
No,
Oh my
I'm
gosh.
sorry. What I said was I'll hear you, Mr.
Don't the Snapples and the Sobe, if you were born and living through the whole Sobe era, my shit was the orange one. I used to think I was like the shit, drinking the Sobe. Do you know what I'm talking about? Okay, we're rambling, but
Mr.
you know what I
Brennan,
mean?
and you.
oh, I'm sorry.
But
After this,
that's
we can ramble.
okay. I don't want to hear about
Got
the
it.
witness
Right.
intimidation statute.
I'm already
Other
up.
than
You already got me
if I
up. Might as well
don't
stay up.
sequester your client, I would be
I ain't going to bed
inclined
now.
to do just like I did before.
What would be the point?
witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a
The green tea was
resolution the
bomb.
court might land on.
Okay.
I do love
Now I'm going to
Arizona.
let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Maybe Bev needs an Arizona green tea.
Your Honor, you have questions?
Yes.
Court
What if he
TV.
takes the 5th?
If he asserts his Fifth Amendment privilege, I think there is no real
Someone tell Court TV I'm not impressed. Is it my internet or Court TV? I'm not impressed with you, Court TV. But Vinny, come get your Court TV under control, please.
realistic likelihood that we would call him. There's obviously
Oh, geez.
procedures the Commonwealth could follow, but
Here
I
we
have no
go.
belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration.
You guys know he's
I
tomorrow,
would ask
Vinny,
the
right?
court to
I'm gonna
impose
be
the
like,
prior limitations with named
I thought you
victims
had
and also
TV on lockdown.
minor witnesses.
Okay.
But I
And-
would, as a predicate, he would
Oh,
need
boy.
to assert his fifth.
Do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
I'm gonna need,
We
yeah.
reject that invitation. If he wants to assert the
I'm gonna
Fifth
need them
Amendment
to get their-
privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
I think they still are 99 cents, which is
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff
rolling
look
my
through lunch for a
eyes.
little bit?
Oh no, they're stuck.
Everybody stay.
I'm rolling my eyes.
Mr. Bradel, why don't I give you 10 minutes to
Look it
talk to
down,
him? We'll see you
Roxanne.
back here in 10 minutes.
All rise for the court, please.
And the fan. We're gonna watch a Karen Reed interview. This is almost over, but we're gonna watch a 14-minute clip of her doing an interview. Is this over? Did I miss something?
I accept those findings.
Fan time. Only fans. Only fans.
Tori,
Oh
Jen.
my gosh! I swear, it could be one of those channels that just comes up here and talks some shit.
All right, so Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth
Attaboy.
concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege.
Invoke?
And
Like you're
I
invoking a bad
find
spirit.
that if he were called
Oh
to
my God.
testify, he would in fact invoke that Fifth Amendment privilege.
Only fans.
So based on that, he
Who's
would
gonna
be
only-
exempt
only
from the
knowing fans?
sequestration
You?
order,
Okay.
except as to, and I need a list of the named
Wait, Tuesday
witnesses
next week?
who have
Oh, yeah,
current,
Tuesday next
who
week.
are the alleged victims in the.
Okay, if you're working, watch it with me. If you're not working, don't be a cheater. Watch it with me. It's gonna be like a Melly marathon. I'm just going to come up here with the balls. It might be members only. I don't know. We'll see. But we're definitely watching the trial. Thank you, Smog Dog. Smog Dog sent me some jewels. Smog Dog. Winning my heart. Crisco. Crisco what? Crisco, like
Current indictments.
the...
I accept those
something?
findings. We'll provide the court with a list
does that
of the
mean?
named victims. We also would like to have the court consider the 2 minors in that list.
Oh, yes, I think I did that last time as
Vegetable
well.
oil?
Thank you very much, Your Honor.
All right, so is that it for
Thank you,
today?
Smog Dog.
Judge, if I may, just for the record, maintain the same objection I had at the
Grab
last
some
trial.
Crisco.
Don't need to make any
Oh,
further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now,
Okay,
but just for the record. Thank you.
okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations?
I
Would you
can't
say
believe
them
the
to me?
trial's
I have
starting.
not had a chance to read them.
I'm freaking out.
Do you, all right, this looks like
Bring that. Because
you all made
popcorn
some progress
Bring your balls.
in a way that, where the jury will be happy that
Bring your
you've
vape.
cut down the amount of time that
Bring your
they
wine.
may be here otherwise.
I'll say, bring your water.
Okay,
Whatever floats your boat.
anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue,
Oh, okay,
if the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
okay, sure.
Doesn't have to be lengthy and
And it is something that we've done.
right, understood. I would like to see what I'm going to have to look at what the law in
I
Massachusetts
don't
is
know.
concerning that and what the sort of parameters.
Has this case become a little like a hype thing? Like everyone's just obsessed with it because it's in the media. You know what I mean? It's one of those things. Don't come for me.
Okay,
I just think because of the
Having
potential
it
prejudicial effect on this.
I'll bring the beer and the
I'd like to
water.
have something in writing, that's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
okay.
Come on, Gun, it's so nice.
All right, thank you all. We'll see you Tuesday.
Thank you.
Oh,
Rise for the court, please.
Tuesday is one of the biggest days of our lives. Okay, we're gonna watch a Karen Reed interview. I should go to bed, but I don't want to go to bed. I'm already drinking the balls. Don't send me to bed now. Okay, we're gonna watch this interview. Let me pull it up. I think we watched it on Amelie After Dark, but I want to watch it tonight, considering the trial starting. I miss y'all. Sometimes I miss not streaming. And shake our asses. Little Smokey, what up? Yeah, I miss not doing the Melly After Darks. It's not even... No, I'm planning on doing a Melly After Dark too, but I've already had a few drinks, so... I don't want Auntie Bev to come after me. I don't want her to come after me. I'm scared. Okay, let's watch this Karen Reed interview.
We find stick. Maybe we can use the. Oh,
Oh,
Look at John O'Keefe.
John died 2 years, 2 months ago. And there's been, an evolution of my emotions about John. The funny thing is, I've now eclipsed the time I knew John. I mean, I knew him when we were younger, but the time I actually dated him more seriously the second time around was just 2 years.
I think it's important, like you guys said earlier. I haven't watched the HBO, the HBO segment. I don't have HBO. Who want to share the login? Because your girl needs it. You have to pay for that? I'm pretty sure you do. Wait, it comes with Disney Plus. I don't watch Disney Plus. Okay, well, I'm gonna have to watch it. But this is from Investigation Discovery. Oh, we're gonna be trouble. Once the Karen Reed trial starts, I'm gonna have to be naming these lives like Melly After Dark, 18 and older, please. Just kidding. No, but really,
Shy of 2 years.
it's about to get
And now he's
crazy
been
up in
gone
here.
24 months. I think anybody who witnessed us around
No, I
Keaton
don't
at
like
kids'
Disney.
sporting events or out to eat or at bars would say we were always getting along.
You had occasion to meet or see Karen Reed over the course of hanging out with your brother at various occasions, correct?
Correct, yep.
What, if any, occasions, as far as their arguing or anything like that, did you observe personally yourself?
This
I
is
witnessed-
crazy.
I
I want to
one
watch some of
intense
the trial.
fight
Are you guys
between the
down?
two of them.
And as far as the fight, as you're characterizing that, was that
I
anything
think it's
physical or
important
just
to watch.
No, it was a verbal argument.
And what, if anything, was that verbal argument about?
It's hard to recall. I mean, I guess like typical couples fighting. There was alcohol had been involved.
Quite a bit of
her
Mhm.
complaining that he wasn't nice to her, or something to that effect. And
Mhm.
I was kind of the referee in that entire situation.
A few days before he died, John hung a chandelier in my house, in my stairwell, which is, I've hung chandeliers in my house, but not in the stairwell. And John brought his ladder and rolled his sleeves up, and I was cooking for him and to thank him for hanging the chandelier. And in the first few months after his death, when I was trying to figure out what had happened to him, and I was still getting evidence to piece it together, every time I'd go up and down my stairs from my bedroom down to the kitchen, I'd turn the light on. I'd be like, all right, just literally and figuratively, please enlighten me, John. The first 6 months and 9 months, I missed the role that John had in my life and my routine, and talking to him and just going to the phone and he's not there. And I can't even
Wait.
I've never dated someone or been intimate with someone that they're just completely extricated. You can't get a hold of them anymore.
This is weird. Come for me, don't come for me. This whole interview, this whole thing is like weird for me. I don't know. It's making me feel some type of way. Not that I'm judging Karen, but like, what? Why are you going on an interview talking like this when you're about to be
It's just
convicted?
a weird feeling, but now I just want to save myself, and I just
Don't
want
come
to be who I was before this, and I care
No, my wife.
less about fighting for John.
At the hospital, Karen Reed's blood alcohol level was tested. I think for the prosecution, proving that she had been drinking is critical for the charges she's facing.
I'm just showing you a document as far as some medical records in relation to a patient named Karen Reed that visited the Good Samaritan on January 29th, 2022. Is that correct?
Correct.
You see a record in regard to a lab results for alcohol testing with regard to Ms. Reed.
Yes.
And what is it reported as, sir?
It is reported at 93 milligrams per deciliter.
According to the police reports, it says that Karen didn't even remember if she was at 34 Fairview Road the night before. And according to them, was disoriented and having a hard time putting the pieces of the night together. And so they did what's called this retrograde analysis, where they took Karen's blood alcohol level the next morning in the emergency room and say, okay, if she's had this much alcohol in her blood at 9 a.m, this is what we believe she could have had, at 12:30 or when they believe John O'Keefe was killed. And it was well above the legal limit.
This is the retrograde extrapolation report that I did for the subject of Karen Reed.
What, if any, result did you get from your mathematical calculations in regard to that?
The result was a 0.292 gram percent at 12:45.
That'd be 12:45 a.m. Is that correct?
Correct.
Karen has not denied that she was drinking that night. She's not stumbling. She appears to be in control of herself. And so,
Janetti.
I think this is another area where I think the prosecution
I do really
has
like him.
problems.
I know I wasn't driving recklessly. I mean, I've got plenty of video of myself driving all over the place. I did put my car in John's garage, which is incredibly narrow, and I had a very oversized SUV. It's not lost on me. This wouldn't have happened if I wasn't out that night. This wouldn't have happened if I didn't go to 34 Fairview, and it wouldn't have happened if I went out for dinner with John and had a glass of wine. So I was in the wrong place at the wrong time, but I didn't start out the night at the right place either and doing the right thing. And I feel terrible about that, but I was not driving recklessly by any measure. Reading through all these reports from the EMTs and the medical examiner, what I've learned is that when you find someone who appears to be a victim of hypothermia, you can't pronounce them dead until you try to warm the body to get the core temp back. So when they found him on the lawn, his body temp was like 80.1 degrees, but they wanted to see if they could warm him and try to defibrillate him and see if that would make a difference. And it didn't. So once they stopped resuscitation efforts, they pronounced him dead at 7:59.
Get ready.
But he never actually registered
you never know what you're gonna get, baby.
He was in cardiac arrest. He was dead when they got to him at 6:08.
I'm a bad influence. Oh no. Here we go.
So one of the mysteries that still remains about this case is missing ring videos from John O'Keefe's.
Why do they have him on this? I'm not a fan of that channel. Yellow Cottage Shells.
There's ring camera video from like 11:30 the night before on the 28th when Michael Camerano comes to the house to pick up his daughter. And there's ring camera video the next time at 5:07 a.m. when Karen Reed is leaving.
Live.
If you do natural math, there's a point in time when Karen Reed comes home and puts her car in the garage in between those two time periods, but there's no ring camera footage of that.
Hey, eyes never lie.
We know the ring video had to be deleted because at 12:41, I leave a voicemail to John where you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage door. Beep, 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 beep. And then you hear the car go off, and then you hear the sled ding, ding, ding as I open the door, shut the door. I had high heels on that night. You hear me walk in, go in through the stairs up into the kitchen, shut the door, and you hear me walk into the kitchen. It's like a full minute long. That's at 12:41. But the ring video of me arriving home is mysteriously missing. The prosecution is accusing me of deleting the ring, and we're accusing them.
The O'Keefe family believes that when they did this was when Karen got home from the hospital with her dad.
There was certainly some evidence in this trial that Karen Reed got home and had gone up to John O'Keefe's bedroom.
And if you know about how long were they in the upstairs area of the house?
We're gonna watch some of this.
I would say 10 to 15 minutes.
Karen Reed had access to the computer in the bedroom, so there's a possibility or an inference that she could have deleted ring footage.
Second trial or not, the way the mind and the psychology of the brain works is that you remember the first time around. So whether the second trial changes people's mind or not, you remember your initial reaction to that case and what we first saw. It's just like an imprint on our brain. It's not something we can control. We've all kind of made up our minds, right? Whether there's a second trial or not.
That she didn't believe was favorable to her.
So this would have been the time that Ms. Reed, the defendant, arrived with her family from the hospital as well?
Correct.
Why am I deleting these videos? If anything, I mean, I want the video when I arrive home to show that my taillight's intact. I don't know that it would have captured it, but it could have. They wouldn't want that video in because it would show my taillights intact. So who has a greater incentive to delete the video?
No, stop being annoying, please. No.
So this brings us to Officer Barrows.
Yeah, myself,
Officer
Rosa.
Barrows, I don't even really want to cross his name out because he was so amazing. He was a witness that we did not know.
I don't see myself frozen.
I was going to say what he said, but he ended up being just amazing. I mean, he was supposed to be relatively innocuous. He just showed up to support the
Was I frozen for a
Police
minute?
in the towing of Karen's car.
The moment that I was frozen, imagine I'm sucking your soul out of your body.
What he ended up doing is coming to court and blowing a hole completely into the Commonwealth's case.
I received a phone call from the Norfolk District Attorney's Office with the troopers assigned there, and they had stated that they were going to come to Dighton to retrieve a vehicle that was involved in a homicide. The troopers just had asked me if I could meet them at that residence, as a courtesy since they were coming into my jurisdiction.
Did you observe a vehicle in the driveway at any time?
Yes, we observed a black Lexus SUV in the driveway.
And what, if any, observations
Oh,
did you
Lord.
make to the?
I saw that there
No,
was
I
some
was
damage
joking
to
because
the
you guys were all
right
saying
rear
that I was
taillight.
frozen. So I was like, while I was frozen, it was flicking your soul. Yeah, I'm good. It was just a joke.
To my best ability and recollection, that tail light
And I was
was
like,
not
what?
completely damaged. It was cracked, and a piece was missing, but not completely
No,
damaged.
you guys said I was frozen. I didn't say I was frozen.
Barrows was
Shout out.
absolutely a gift. He was very, very clear in his testimony that Karen's taillight that morning or that day was cracked, not completely damaged. So that was an incredibly important moment.
The right
I like to hear.
rear taillight had
I like them to be
large
interviewed.
pieces missing from it.
Oh no.
And to have that
Not
statement sort
Proctor.
of juxtaposed with Trooper Proctor testifying, not days later, but literally minutes later, when that was still fresh in the juror's mind, to a completely different description of what her taillight supposedly looked like that afternoon, I think was incredibly important for the jury to see.
I would love to go on the stand, and in lieu of that, I'm sitting here talking. I was adamant about taking the stand, and then the lawyers explained to me, if we're winning, which we expect to be, one of
Wow.
the last things the jurors are going to hear is Adam Lally's cross of you, and he's going to try his best to jam you up. And do I want to get? What is he going to ask me? What is he going to confront me with? Am I not going to answer it perfectly? And is that the last thing we want jurors to hear? And that scared me a little bit. I'll do whatever. I defer to the lawyers. They want me to, or if they're 50-50, I don't know, I'll just defer to them. I'd like to, but I'll be okay if I don't.
Who's take out?
John did leave the bar that night with a cocktail glass. He brought it in my car. And then when I dropped him off at Brian Albert's house, he took the cocktail glass out and walked up. He just took it with him.
The cocktail glass was found near John's body.
I was removing the snow layer by layer. And right here,
I don't like this guy.
you can see it exposing a broken clear cocktail glass.
The cocktail glass was the very first piece of physical
is
evidence
this?
presented in the trial.
Your Honor, with the court's permission, I would ask that the witness be allowed to take it out of the bag and display it to the jury.
Okay. I think I need another buzz ball.
How it got broken at the scene, whether it
You have
got
another
broken
clip
in the
after this,
house
so-
and was put
I hope
outside,
you're ready for it.
or he dropped it. I mean,
You
we
complaining
don't
I
know.
I didn't
We
go
know
live
that
this
we
weekend,
have
then
a
you better
damaged
figure out.
drinking glass at the scene in the vicinity of the fragments of the taillight. So the
Oh,
theory that Dr.
oh,
Rentschler and I put forward
Cash Daddy.
is potentially an individual threw this drinking glass at the back of the Lexus, causing the taillight to fracture. So myself and one of our lab technicians at ARCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight.
They fired a cocktail glass out of a cannon at various miles an hour to determine how fast one would have to throw a cocktail glass to break Karen Reed's taillight. And they ended up coming up with
And who
37
is
miles an
this?
hour. But the state had never presented a theory that John had maybe thrown a glass at the car in anger, and neither had the defense. So when those ARCA experts testified about this John throwing the glass theory, that was the first time anybody in that courtroom had heard it.
It doesn't make sense.
I could see
because
that.
The cocktail glass was
Wait,
found near
no. I can see them throwing the glass. I said it earlier. Were they fighting? Maybe they were fighting. She didn't mean to back up into him. Maybe he threw the glass. Maybe they were physically abusive. I don't know. It was a toxic relationship. There's so many things I think that can play out here. Don't ask me what I'm able to have. You're here on my channel. Can you handle Melly having another buzz ball?
John.
That's
If
the real
he had thrown
question.
the glass, it would have been found somewhere completely else, far away from him. So I think physics would suggest that the glass was in his hand and broke as a result of the collision.
Not cute. Oh. Wait, is that what you guys are telling me I have to watch? Oh no, it was HBO one. Okay, I want to play. We're gonna watch Proctor's. I want to watch his testimony from the last trial. I think his is
Thank you,
super
Jackson.
important.
Trooper Proctor, I'm going to ask you if you wouldn't mind to turn to tab 2 in the binder in front of you.
If it's it's if a YouTube can handle.
Can you take a look at the face page of what's under tab 2 and tell me if you
Okay, this
recognize that?
is the previous trial. We're gonna listen to Pooper Proctor.
Yes, sir. It's
Trooper Proctor.
a private text
Yeah.
thread with
You
high school
wanted me to
friends.
come.
And this
come up
includes
here.
9 participants, 9 chat participants that you engaged
Okay,
with.
perfect.
That's correct.
Begin with the buzz ball.
Those participants include people by the name of Bird, Whitey, and Doc, correct?
Correct.
And then there's some other folks in there. They're identified by at least the last 4 digits of their phone number, correct?
Yes.
So this is a group text or a group chat with you and 8 of your high school friends about this investigation, correct?
Yes.
Trooper Proctor, you never thought when you were engaged with these other 8 individuals that this particular set of chats would ever become public, did you?
No, I do not.
I want to take a look at page 2527, if you could turn, that's on the bottom right of the document in tab 2. Do you have that page in front of you?
Yes, sir.
You recognize that this group chat was taking place on January 29th at about 10:52 p.m., correct?
Correct.
And the person that I'll identify as 5051, that's the last 4 digits of that phone number, indicates Chip, name of that BPD cop, correct?
Correct.
First of all, you indicated on Monday that you're Chip, is that right?
Yes, sir.
You responded at 10:53 p.m., John O'Keefe, is that right?
Yes, sir.
So you were willing to tell just a few hours into an investigation of the death of a
Wait,
Boston
what?
police officer, you were willing to tell a bunch of high school buddies details about the investigation, including the name of the victim, correct?
At this point, it was 16 hours later, sir. Not a few.
16 is a few hours, correct? I'm not talking about days later.
It was about 16 hours later, sir.
Correct. And you identified John O'Keefe as the Boston police officer who is fallen in the yard at 34 Fairview, correct?
Correct.
You also informed, if you will skip to page 2529, you also informed these same folks, these same high school buddies that, quote, all the powers that be want answers ASAP, correct?
Yes.
You knew, Trooper Proctor, that there was brass that wanted this case wrapped up quickly and efficiently. Isn't that right?
Objection.
I'll allow that. Is that what you were thinking?
No, the people wanted answers, sir.
They didn't just want answers. They wanted answers ASAP. What does ASAP mean?
That's as soon as possible.
Right. And you were texting this to your high school friends, again, 16 hours
We know Proctor was fired now, moving to the new trial, but
into this investigation, right?
I want to watch this.
And you knew at that time, Trooper Proctor, that this was not going to implicate in any way, shape, form, or fashion another cop, correct?
Correct.
In this text exchange, let's turn to 2532, actually. You have that in front of you?
I do.
In this text exchange at 10:56 p.m., your buddy Bird writes, I'm sure the owners of the house will receive some shit, correct?
Correct.
How did you take that to mean? Did you take that to mean that he could get in trouble?
Yeah, I'm not sure exactly what my friend was getting at.
Well, you had some idea.
Yeah, maybe
The owners of the house isn't going to get any shit for this, right?
That's how I interpreted it.
Yeah, you interpreted it like he's not going to get in any trouble. He's not going to be a suspect, correct?
Correct.
And he's not going to be implicated in any way. Is that right?
Correct.
And your answer was one word, correct?
Yes.
What was that word?
Nope.
And then you followed that up with an explanation as to why you said no, didn't you?
That wasn't the explanation why I said nope. I simply said homeowner was a Boston cop too, meaning Mr. O'Keefe was a Boston cop. The homeowner was a Boston cop as well.
Oh,
The question that preceded your answer, nope, the homeowner's a Boston cop too, was the homeowner's going to get some shit for this, correct?
That's not what I meant with that text.
That's what you wrote.
what did he mean?
Not what I meant, sir.
All right, let's take it in order. Question. Oh goodness, the homeowner's going to get some shit for this. Answer, nope. Next text, he's a Boston cop too. That doesn't sound like an explanation for your nope.
No, that's just saying he's a Boston cop as well. Mr. O'Keefe is a
And that's
Boston
why
cop.
he's not going to get any shit. Correct, Trooper Proctor?
Well, he's not going to receive any shit, sir, because Mr. Albert, the homeowner, had nothing to do with Mr. O'Keefe's death.
And you knew this 16 hours into your investigation.
Yes.
Less than a day.
Yes.
To your satisfaction.
To my satisfaction
And
and
you
to the
hadn't
members
been
of my
to the
unit.
crime scene?
So let him finish. We didn't get the, finish
Some-
your answer.
To my satisfaction and to all the members of my unit who investigated that day.
Objection. Calls for speculation.
So I'm going to let it stand. Trooper Proctor, you have to keep your voice up, okay? Jurors need to hear you way back there.
Yes, ma'am.
The fact of the matter is, you hadn't been to the crime scene by the time you wrote this text, correct?
Correct.
You hadn't been inside the home, correct?
No.
You had you had questioned a grand total of 3 percipient witnesses at this point, correct?
Yes.
And 2 of the 3 were named McCabe.
Whose Easter eggs am I looking for? Who's got the colorful eggs?
Right?
Correct.
And 1 of the 3 was named Albert, correct?
Yes.
And it's against that backdrop that you wrote, nope, the homeowner's not going to get any shit because he's a cop, right?
That's not what I meant by that.
At 10:57, Bird goes on to write, he, the homeowner, must have been a puddle to accomplish that. And then he writes, who's the homeowner? And then he writes, I hope not, but I can see it. Correct?
Yes.
A puddle means drunk, correct?
That's a term for it, yes.
In other words, Bird wrote that the homeowner must have been so drunk, so wasted to have killed him. Correct?
Objection.
Do you know what that means? Do you know what that text means?
Just the puddle part, Your Honor. That term.
All right, so he can answer that.
And the puddle part means drunk or wasted, right?
Yes.
And what Bird actually wrote was, he must have been a puddle to accomplish that. Correct?
That's what he wrote.
And then you write back, quote, she waffled him. I looked at his body at the hospital, right?
Correct.
You used the phrase waffled about a Boston police officer who had fallen in the snow and died in someone's yard. And you decided to use the word waffled him, correct?
Objection.
So sustained. Ask it differently, Mr. Jackson.
I can't have the ball.
Did you answer, she waffled him, I looked at his body at the hospital?
I did answer that, yes.
And then Bird questioned, she waffled him, correct?
Yes.
And then you responded, he was banged up. Is that right?
Yes.
Then a person with the phone number 0095
He was
wrote,
banged up
I thought he was drunk.
from the car.
Did he get beat up? You see that?
I do.
And you wrote, nope. Is that right?
Correct.
Yet again, this is before 11 o'clock at night on January 29th, 2022, some 16 hours into your investigation. Is that right?
Yes.
So before you ever went to the crime scene, before you ever went into the house, only having interviewed 3 folks, you had this case nice and wrapped up, didn't you?
Yes. Based on the evidence my office uncovered that day, the one shoot discovered at the scene, the one shoot at the hospital, Mr. O'Keefe's injuries.
Why did he
The
deny
broken
that?
taillight piece is underneath the snow.
Super Proctor, I didn't ask for an explanation. I asked, did you, in your mind, have this case wrapped up? Was it cut and dry in your mind?
Yes.
Bird then writes, so the owner of the house was a woman. Sorry, was a woman cop that beat him? Question mark, right?
Yes.
And then you wrote, that's what I initially thought after talking to Canton paramedics. Is that right?
Yes.
And then you said, then I saw the guy, correct?
Correct.
So what you meant by that, Trooper Proctor, was according to you, based on your conversations, your initial conversations with the paramedics, the first responders, you were under the impression that this was a beating death. He'd been beaten to death, correct?
The way it was given to me, sir, was
That's yes
for
or
medical.
No? That's yes or no?
He's going to answer the question. You want
Go
to
ahead.
withdraw the question?
No, go ahead.
If we enter this investigation
Someone tell Bev to chill the fuck out.
with an open mind, it was given to me as a medical situation.
Penny.
And when we saw Mr. O'Keefe's body at the hospital,
User.
Sergeant Buchanan and I, we saw his injuries and we were kind of working through
Good to see you.
how these injuries occurred.
As a matter of fact, both you and Sergeant Buchanan believed that he had suffered the injuries as a result of a physical altercation based on information you received from the paramedics initially, correct?
Initially, we didn't know what we had. We knew there was some significant injuries to Mr. O'Keefe. And we're still figuring out how those injuries occurred.
Well, you just testified. Initially, we didn't know what we had.
Right.
But 16 hours after the fact, you wrote the following sentence. That's what I initially thought after talking to Canton paramedics, correct?
Correct.
So initially, you did think you knew what you had, a physical altercation leading to a death, correct?
Correct.
Yeah, someone give.
So when you just said,
Bev a
initially
buzz
we
ball.
didn't know what we had, that wasn't quite true. You did at least have an idea of what you thought you had, correct?
Objection.
Sustained.
All right. You were aware initially that John O'Keefe had suffered a 2-inch laceration to the back of his head, correct?
Yes.
That resulted in a skull fracture, correct?
Correct.
He had a laceration over his right eye, small laceration just under the eyebrow, correct?
Yes.
Had a laceration on his nose.
Who
Is that right?
believes him?
Correct.
He had patterned scratches
I'm just
on his
curious.
right arm, abrasions, scratches, correct?
Yes.
And he had no injuries.
I'm just curious who wants to bone Pooper Proctor because unless this is his wife, I'm not sure.
Below the neck.
Not that I observed, sir.
Not a
I'm not trying
single
to be,
broken
not, I'm
bone.
not trying to be mean. I'm
Correct.
just saying.
Not that I was aware of.
Not a single fracture.
Don't come for
Correct.
me. I'm not being
Not that I was
bully.
aware of.
Not being
Not a
mean,
single
I'm just-
bruise below the neck,
isn't
right?
typically.
Not that I observed.
Looks a lot like a physical altercation, doesn't it?
Objection.
Sustained.
Do you know what I'm saying? Do I even have to say anything?
Bird writes,
I feel like I don't have to say.
Bear, let's focus, correct?
Share my feelings.
Yes.
Who's Bear?
That's another
right
nickname
there.
I have.
Then I'll block you.
0095 writes, what does she waffled him mean? And then Bird writes, what's the story, correct?
Correct.
And you wrote, she hit him with her car. Is that right?
Yes.
Have you ever
Give me a
seen,
lick or
in
the
your
dog's
experience,
like
have you ever seen
going
a
back to the
pedestrian
dream.
who was hit by a
Not
6,000
my dream,
pound
by the way.
car with no bruises?
I might have some dreams tonight. I might have a dream.
The pedestrian strikes I've seen have been at high speeds,
And that's
60
enough
plus.
A person out of the shoe.
He's
right?
very New England.
60 plus miles per hour.
Yeah, I'm not impressed with
So I can't recall right now, off the top of my head, as far as
You can tell
injuries in
him,
the
like,
past pedestrian
do
strikes
better.
I've attended.
I don't know.
Okay. So someone, you indicated on
Oh, Alan
Monday,
Jackson. Yeah.
examination by Mr. Lally,
Someone tell Alan
seen
Jackson, call Melly up right
machinist
now.
Correct.
pedestrian strikes.
Phone
correct?
numbers
Yes.
800.
Those are high speed,
866.
extremely high speed incidents.
Melly
correct?
12.
Yes.
That's the
60
phone
plus
number.
miles an hour, right?
So please.
I
everyone
can't
knows.
recall all the pedestrian strikes I've been to as far as the miles per hour the vehicle is traveling.
Trooper Proctor, let me ask you the question again. Have you ever, yes or no, have you ever in your experience seen a vehicle, pedestrian
I'm gonna
incident,
speak to
in which
Bev.
the pedestrian has no bruises?
Ever
Objection.
have that big blonde hair
Have
all
you
up in
seen
your
that?
face, Austin.
I can't recall.
The wig.
Next question.
With that wig just like hitting you in the face.
After you wrote, she hit him with her
Eyes
car,
off.
5051 writes, oh Jesus,
I'm just kidding.
and Bird writes,
back.
okay, that's fucked up, correct?
Correct.
And then you wrote what?
I'm not trying to be mean.
Intentional or not?
Intentional or not? Is that right?
Yes.
Your words.
Correct.
0095 then chimes in, gotcha. He was frozen in the driveway and she didn't see him? Question mark. Correct?
Correct.
And you wrote what?
That's another animal we won't be able to prove.
That's another animal we won't be able to prove. Correct?
Correct.
Trooper Proctor, you knew that there were.
Imagine getting fired for this. Ugh. My heart. The embarrassment. The pride. Whether or not you care. The pride. I'm like, I can't. You got fired for being a faulty police officer and being inappropriate.
Were going to be things in this case, even 16 hours into this, that you just admitted you would have zero proof of, correct?
Was it worth it? Was it worth losing
Sustained.
your
You can ask it
career?
differently.
Was
Did you
it?
mean by that statement
Pooper
that this was
Proctor.
one of several things that you knew we would not be able to prove?
That statement, that's another animal we won't be able to prove, references the intentional or not part.
You didn't care at that point when you wrote that, you didn't care what you could or could not prove, did you?
Objection.
I'll allow it.
Oh my God,
Isn't that what you meant?
No.
You had a narrative that you had developed and you would pursue it no matter what the proof was. That's what you meant by that statement, correct?
Objection.
Sustained. You can ask it differently. Mr.
Did you mean by that, thank you, Your Honor, I didn't mean to step on your words. Did you mean by that statement that you were going to pursue this case no matter what the proof might be?
What I meant by that statement was if
Kat Rondell makes a great point. What would you think if that was texted about you, your mom, sister? Regardless, if I was involved in a criminal case and an officer was talking about me like that, I would definitely pursue it. Definitely, 1000%. I think any of us would.
Ms. Reed backed into
is
Mr. O'Keefe intentionally or not.
Disgusting law enforcement behavior.
Interestingly, though, that statement came on the heels of he was frozen in
I
the
feel like I need a
driveway
shower after I
and
watch
she
it.
didn't see him. And you wrote in response to that question, that's another animal we won't be able to prove. Correct?
That's not what I was
Losing your
responding
job,
to. I was
yeah.
responding to the intentional or not part.
So you were responding to your own statement.
Correct.
Okay. 0095
Ew.
then
I
writes,
mean,
what's the name of the Canton cop living in Canton? The other one involved. Correct?
Yes.
In other words,
what?
that person was asking, tell me the name of the homeowner. Isn't that right?
Yes.
The guy that's the cop, right?
Correct.
And you ignored that question for a second time. Is that right?
Yes.
As a matter of fact, not one time, not once in this entire group chat did you disclose the name Brian Albert, did you?
I don't believe so, no.
You were actively trying to hide Brian Albert's name, at least from this conversation.
Objection.
I'll allow it. Is that what you were trying to do?
Absolutely not.
Is that what you were
But you had
trying
no
to
problem
do?
sharing John O'Keefe's name
Oh my
with your
God.
buddies from high school, right?
Correct.
And you had no problem sharing Karen Reed's name with your buddies from high school, correct?
I don't believe I named the defendant.
Not yet, you didn't. Later in the chat.
Okay, correct.
5051 then writes, the BPD have any jurisdiction here because it was their own? Question mark. Is that right?
Yes.
And a few texts later, if you look down a few texts, at about 11 o'clock, you see a text that starts, nah, cat.
I do, sir. Yes.
You responded, quote,
I do think the text.
nah,
messages from
N-A-H,
Proctor
nah,
clearly.
cat, K-A-T-T.
I do. I'm sorry.
It's the total opposite.
It's disgusting.
They have to recuse themselves.
It proves
Same with
they
Canton.
are sus.
Correct?
Or even the investigation.
That text ends as they have to recuse themselves.
You then text back. I'm sorry. Can I have a moment?
Yes.
Flip the next page.
I see where you're at, sir.
How did you end that text?
Same with Canton.
Meaning Canton has to recuse itself also, correct?
That was my understanding.
So by 11 p.m. on January 29th, 2022, there was no question in your mind, Trooper Proctor, that the Canton Police Department was recused from this investigation in all particulars, correct?
That they had taken a step back from participating, yes.
Right. Well, there's one way to put it. They've taken a step back from participating. Another way to put it is they recused themselves completely, correct?
Correct.
They were not going to be, at least in your mind, they were not to be involved in any way, just like Boston PD was not to be involved in any way. Is that right?
Objection.
Is that what you were thinking?
It was my understanding they were not going to be involved.
Is that what you were thinking?
Now, if we could turn to
I've never had a
page
judge
2537.
I've never had a judge ask me that. Have you, like, oh, ma'am, is that what you were thinking when you got pulled over?
'5051 writes, but I assume you guys are out to make it cut and dry since it involves cops, correct?
Yes.
And Berg writes, something stinks, correct?
Correct.
And then Trooper Proctor, you responded, yeah, but there will be some serious charges brought on the girl. Isn't that right?
That's right.
So in that text exchange, you were saying, yeah, we're out to make it cut and dry, correct?
No.
You didn't write, yeah, we're going to follow the evidence wherever it takes us. You didn't, did you?
I did not write that.
You didn't write, yeah, we're going to make sure that we investigate this thing fully and thoroughly.
Could it have just been that everyone was messed up one night and they got into a fight and Karen was fighting with him? Like, could it have all just been wrong place, wrong time? I know it's hard to envision that, but it's important to have an open mind, whether you think she's going to turn out. There's other possibilities. That's why it's second trial, one of the biggest cases in the true crime community. It's wild.
Before making any decisions. You didn't say that, did you?
Reasonable doubt.
I did not.
You wrote, yeah,
That's where the
but there will be
yeah.
some serious charges
Ooh,
brought on the girl.
leaky balloon.
Isn't that right?
Correct.
And the reason you wrote that is because you knew, as the text above it says, this has to be cut and dry because it involves cops, right?
Objection.
I'm going to allow that. Is that the reason you wrote it?
No, Your Honor.
And then you indicated we're going to put serious charges on.
Why does she
the
ask
girl.
that?
Who did you mean by the
Sir.
girl, by the way?
The defendant.
Sir, did you write that, sir?
Read.
Yes, sir.
So the way that you were
Like
going to
what?
make it cut and dry,
Dude, isn't this
pretty simple.
evidence or something?
Just pin it on the girl, right?
Objection.
Is that right?
Absolutely not. Follow the facts and the evidence from that day on the 29th. And everything led to Miss Reed hitting Mr. O'Keefe with her vehicle.
Pooper, Proctor, everything's leading to your douchebag, your douche canoe. You were an officer. Don't talk about people like this. Whether you like Karen or not, suck it up. You had a role to fulfill.
But that wasn't the
I don't wanna
question
hear
that
the
you were
bullshit.
answering, was it? We're going to
Someone tell
follow the
Proctor
evidence
I
and
wanna
make
hear
sure
the
we do this thoroughly. The question you were
Proctor.
answering was, I assume you guys, you, Trooper Proctor, and your team are going to, quote, make it cut and dry. since it involves cops, meaning Brian Albert, correct?
Incorrect.
That's my point.
It doesn't matter to me
Yes.
if the homeowner's a cop, if the victim's a police officer. Myself and everyone in my
You got
office
the record.
investigated this case that Saturday, had an overwhelming amount of evidence that Miss Reed struck Mr. O'Keefe. So it didn't matter to us what their occupation was.
We'll see. Let's keep reading, shall we?
Look at Yannetti. He's like,
5051.
No.
A little further down says, gotta be. I could only imagine what internal
I kinda
affairs
like
at BPD are trying to get out there. Correct?
I have a little
Correct.
Meaning, this person, 5051, was opining, at least in
Not
your
on this
mind.
guy. Oh my
You
God.
interpreted that as being
My eyeballs.
Boston police are going to have a lot to answer for, given the fact that another Boston police officer was found dead on that officer's lawn. Correct?
Being problematic here tonight.
What were you thinking?
Can't speak to the mindset
Let's
to that
go
comment.
subscribe and hit the like button.
I wasn't sure how to
Hello.
interpret that one.
All right, next question,
Yeah.
Mr. Jackson.
Then 5051
Milliverse is
changes
one of the
gears
If you can't
and he
hang,
writes, she
Super
hot at
Proctor
least,
is probably your man.
correct?
Not me.
Yes.
And what was your response to that?
Okay, Bob.
From all accounts, he didn't do a thing wrong.
If you're telling the truth, why do you have to refer back to your report? Why do you have to remember what you said if you were telling the truth? That's the thing about lies. Like, why can't he remember shite? Smog Dog, thank you for gifting. Oh my God, so many members of Mellyverse. I better put out a disclaimer like, hey. Warning. Membership comes with a girl who drinks the balls. No, but anyways, like, thank you, Smog Dog. I appreciate you so very much for gifting membership. Let's go back to Pooper Proctor. Like, I lost my train of thought, but like, what is this? And I just think, I don't know if we heard the leaky balloon part yet, or if that was another part of the trial, but like, so disgusting. So disgusting when you would talk about someone and their medical conditions. I can't. Those are things I won't deal with. I'll deal with a lot of shit. You deal with a lot of my shit. I can't with the whole.
She's a whack job cunt.
And
accounts,
oof, I don't use that word in my
affairs at
vocabulary.
BPD are trying to get out there.
I'll shake my ass up here, whatever you wanted me to do, but like, I will not use that word in my vocabulary.
Correct?
Correct.
No.
Meaning,
Thank you, Smog Dog, for
this
gifting.
person, 5051, was opining, at least in your mind. You
I
interpreted that as being Boston police are going to have a lot to answer for, given the fact that another Boston police officer was found dead on that officer's lawn. Correct?
Objection.
What were you thinking?
Can't speak to the mindset to that comment. I wasn't sure how to interpret that one.
All right, next question, Mr. Jackson.
Then 5051 changes
Your mindset.
gears. And he writes, she hot at least. Correct?
Yes.
And what was your response to that?
From all accounts, he didn't do a thing wrong. She's a whack job cunt.
From all accounts, he didn't do a thing wrong.
That did it for me.
She's a whack job cunt.
I can't. That word is not allowed in my vocabulary. It's not allowed here. We can watch it in the videos. I don't like it. I don't fucking like it. It's not acceptable. This is disgusting behavior.
That's what you wrote.
I don't.
Correct?
Correct.
I don't.
16 hours into this investigation,
Yes.
into your objective and unbiased, thorough investigation. Correct?
Correct.
It's my channel.
But sir, you
Not
didn't
allowed here.
have all accounts,
Disgusting. It's degrading.
did you?
Oh, a lot of shit. Trust me. I ain't
What I meant
perfect.
by that was
Did you or did you not have
I can't do
all
it.
accounts in your investigation?
the accounts we had was Miss Reed struck Mr. O'Keefe with her vehicle, discovered taillight pieces at the scene. Those are the accounts we had.
The accounts
And then
you
some.
had, I'm sorry, go ahead.
I'm sorry, go ahead.
The
No.
accounts you had, Trooper Proctor,
Do you see how he's like, oh, I'm sorry, go ahead. Oh, I'm sorry, go ahead. Like, can someone tell Auntie Bev with her wig, like, just allow people to talk, Auntie Bev? Auntie Bev, you might need some balls in your life.
Were from two people named McCabe and one named Albert,
And I mean that
who happened
genuinely.
to be the
I'm so
homeowner
concerned
and a Boston cop.
for her
Those
welfare.
are the accounts from recipient witnesses that you had, correct?
There was another additional witness that we had investigators had interviewed, Miss
If y'all
Roberts as
don't
well.
get my person,
And
so
from all
sarcastic right
accounts,
now.
he didn't do a thing wrong. That was your decision 16
No, I
hours
mean,
into the
the truth
investigation,
about it.
correct?
Yes.
And the other
Yep.
decision that you made and the other determination you came to was my client, Karen Reed, was a whack job cunt, right?
Yes.
Ugh.
What else did you say in response to she's hot at least? Or she hot at least, question mark.
And you're married. And his wife came out and gave an announcement like, wah, 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 I love my husband. He's been tainted. I give no F's about what you're saying, lady. That is your husband. And if he's talking like that, you got issues. I'm just saying, like, why does he feel like he can send these text messages while he's acting in the role of law enforcement? And why would your wife forgive you? I think we saw a clip on that on Amelia After Dark where she like did a little 5-minute interview and she's like, oh my God, the Karen Reed is like touching my life. I'm like, yeah, I don't like, oh my God. No, you knew your husband when you married him. You knew what he was acting and you knew what he said and you chose to stand by him and you're choosing to deal with it. So suck it up. I don't want to hear the bullshit. I don't want to hear it. I don't want to hear it from that lady, his wife. I don't want to hear it. I just don't want to hear it. Oh my God, Mellie's being a mean girl. She's being a bully. That's not the case. It's just, if you can come on social media and defend him, so then I expect to hear nothing from you. Nothing else. I don't want to hear the complaining. I don't want to hear the crying. If you're standing by him, do what you got to do. Just shut the hell up. I'm sorry. Don't get mad at me. Oh my God, don't unsubscribe. I promise.
So following that text, I
promise.
responded. Yeah,
I
she's a
promise I'm
babe.
not a mean.
Weird Fall River accent, though. No ass.
Yeah, she's a babe. Who's the she?
Miss Reed.
Weird Fall River accent,
Wait,
though.
let's go back.
Trooper Proctor, were from two people named McCabe and one named Albert,
Period.
who happened to be the homeowner and a Boston cop. Those are the accounts from recipient witnesses that you had, correct?
There was another additional witness that we had investigators had interviewed, Miss Roberts as well.
And from all accounts, he didn't do a thing wrong. That was your decision 16 hours into the investigation, correct?
Yes.
And the other decision that you made and the other determination you came to was my client, Karen Reed, was a...
Like, let's take it from Poopa Proctor. You're willing to risk your job, what you love in your career, for what? For what? Defending your friends? Maybe not defending your friends. Maybe talking about Karen. Maybe not talking about Karen. Whatever. Maybe you were. You're admitting it here. I mean, was it worth it for something you worked so hard for? Whether you personally think whether it personally means something to you or your family, or you want to do something to please your family. There's so many things. Was it worth it losing your job and your career for this? Like, what happened that made it worth it in that basement? Your friends? Maybe this is the truth. Maybe you were nasty douchebag in those text messages. I don't know. He got fired. This is the first trial, but we know he lost his job. I can't imagine working in law enforcement and working so hard. Maybe I'm just a different type of person, but I can't imagine and just ruining it. I don't know. Maybe that's just like a me thing, but I can't. How do you allow that? What do you have to get into to allow that? To ruin your family, your money, your finances, your well-being, your job, your education, your position. It's wild to me.
Whack job cunt.
It happens. You're
Yes.
right. Which. It's just sad.
What else did you say in response
Makes me
to
sad.
she's hot at least? Or she hot at least? Question mark.
Right?
So
Because like
following
what
that
he
text,
did didn't just affect him and Karen Reed. No, it didn't. It affected his family, clearly. That's why his wife is coming up making interviews. And that's what gets me is like your decisions don't just affect you in life. It affects the people around you, the people that care about you. And if you have no one around you, it affects you. So I just feel like I can't relate to Pooper Proctor.
I responded, yeah, she's a babe. Weird Fall River accent, though. No ass.
No ass.
Yeah, she's a babe. Who's the she?
Miss Reed.
Weird Fall River accent, though. You talking about her, the way she talks?
The accent.
Yeah, exactly.
And no ass.
He took an
Now
oath.
you're talking about her body or physique, correct?
Yes.
You think that's appropriate?
Absolutely not.
And I'm sorry, men. Oh my God. Here we go. Not the men in the chat. I'm just saying men in general. Why are you even talking about a female's body? I can't. Do you want to have a full-blown conversation? Wait for Melly after dark. All sayings like the eyes. Disgusting. Pooper Proctor, why are you talking about someone's ass? There's such thing as like shut the fuck up. There is such thing. Just saying. I totally just put my
When Bird
drink up.
chimes in with a little comedy, not newsworthy then, correct?
Correct.
In other words, well, if she didn't have an ass,
I
nothing
can't
to see
imagine
here,
being
correct?
Objection. I literally spit my drink out everywhere.
And then 5051 says,
Blue
oh,
balls
she's skating,
everywhere
right?
in the memory
Correct.
household.
And what did you write after that?
My
I
response
can't
was zero
imagine being innocent
chance she
speaking so
skated.
negatively about the person's family.
And then what did you write?
She's fucked.
Zero chance she skates. She's fucked, right?
Correct.
You decided on the 29th
Where are
of
his
January,
morals?
17 hours into this investigation,
That's my point too, is like I'm not coming for the wife, but like what are your morals? If you can't even commit to your job and your position, which is so like it's such a big deal. We don't like cops, we don't respect cops, but we respect the field, right? And like what it takes to get there. I'm just disappointed. And I spit my balls out.
you decided individually, Trooper Proctor, you're not only going to put it on the girl.
Oh my God, remind
you
me to tell
decided
you
you're gonna
about a
make
show to watch
This is
after
cut and
this.
dried, and the way you're going to do it is to make
Remind me
sure
about
that
tell you
she's
my story
fucked.
too in the parking lot. Just
That's
remind
what
me.
you were saying.
Remind me.
Objection.
All right, so that's sustained. You can, the content's fine. You have to ask it differently.
17 hours into this investigation, Trooper Proctor, you made the decision that you were going to put it on Miss Reed, didn't you? Put the case on Miss Reed. She was going to catch the case, correct?
No, absolutely not.
What did you mean then when you said she's fucked?
I
After
don't
the
think you
day's
meant that in a good
investigation with
way.
multiple troopers conducting multiple tasks and a debriefing at Canton PD amongst detectives in my office who went through the overwhelming amount of evidence against Miss Reed that she struck Mr. O'Keefe with her vehicle. That's what I meant by that comment.
What you meant by that comment, Trooper Proctor, was you were going to make sure because 5051 had said she's going to skate. She's skating. When you said zero chance she skates, she's fucked. What you meant was I am going to make sure Ms. Reed doesn't skate. She's fucked. That's what you meant, isn't it?
Objection.
Sustained.
And then Bird decides to chime in. Good. No ass bitch. Right?
Whoa.
Yes, that's what he wrote.
And how did you
Right, which
respond to Bird saying, good, no ass bitch?
No ass bitch. I'm just repeating what they said. Don't come for me. I'm horrified. I'm horrified. If anybody feels, again, I reiterate, mommy lesson from Ellie. No. If you feel the need to talk about someone else's look or body, I think you need mental help. In 16 hours, I looked at all that. It's right, which. Scary. Imagine if it was us, too. If that was me, I would be freaking out. I agree with Twitch. It goes back to why I feel the need to talk about. I never got that. I never got that concept. I feel the need to talk about someone else's looks or body. No, I'm sorry. I can't get past it. You can talk so much other shit. Don't be disgusting. Mellyverse lesson 1-on-1. Don't be a disgusting human. Not that any of you are. I'm just saying.
I laughed.
Thought that was funny, did you?
And don't lose your job
Trooper
over
Proctor?
this kind of shit.
Thought that was funny?
It was unprofessional of me. That's something I shouldn't have done.
Well, I think we all know it was unprofessional. There's a lot of things. I'm asking you, did you think it was funny?
No, according to my response at the time, apparently.
Then you sent a picture just to add to it, to pile on, of Miss Reed being arrested, correct?
I get Pooper Proctor's wife sticking by him too. Would you stick by him if he was your husband? I'm just curious. No judgment either. I've never been married, so that's a different perspective, right? Like from you guys giving me opinions if you've been married or been in that kind of relationship to where I can't come in and chime in just the same. That's what I meant about earlier about like perspectives. Be willing to step outside the box and be open-minded about things. If that was your husband, would you stick around? If your husband was on trial in one of the most corrupt cases and he's sitting there talking about getting nudes from this person as a cop and bless your heart if you can move past that. I will not, and I cannot. Absolutely not. My husband better not be talking like that about anyone, whether it's on the job or not. I'm going to blink my eyes so much. They just pop out of my head. No, I'm just kidding. He's not innocent. She probably has another option. And that's sad. It's sad, witch. But why defend someone like that, even if it is your husband? The loyalty, I get it. Oh, I ride big on that. Trust me. Just so much has come out from this case.
Not sure if that came from me, sir.
Oh, he thought that.
Let's skip to 2543.
Heck no, now he doesn't get his retirement.
Are you there, Trooper Proctor?
I don't know. I just think it's so trashy what he did from law enforcement. Not that I think highly of law enforcement. I don't. I have myself have been caught up with law enforcement before. I want to share that story too. I think we should do like a Millie After Dark and share our feelings and emotions. You know me, I like to get deep. She probably used to that behavior. 5 cats, you're right. She probably is used to it. Okay, so if someone can get used to that behavior, does that mean that you are a bad person? Is that like abusive to some extent? I don't know if like your partner gets used to you being a gaslighter and a manipulative asshole. Is that like abusive to some extent? I believe it is. I question a lot behind that marriage. It's not my business. It's not my business. Melanie, you're not involved, but we are involved because Pooper Proctor was over here talking about her ass while he was married. Do I need to say more?
Yes.
I feel like that's pretty clear.
The date is now.
Why is your
February
husband
2nd,
talking about another
2022.
one's ass?
A person by the name of Doc writes, "Is that chick a smoke?" Correct?
Correct.
Who's the chick?
Miss Reed.
And you write E-H, right?
Yes.
And then you write nutbag, as Chief would say, correct?
Nutbag?
Who's Chief?
A friend of mine.
And then you write what?
Ew, well, keep your feelings to yourself.
She's got a leaky balloon knot.
Trooper Proctor, explain to the jurors what a balloon knot is.
A balloon knot?
Your essentially, I guess, your rectum area.
Your anus?
Yes.
Oh my God.
That's what you were referring to about Miss Reed?
Yes.
And you were making fun of her because you believed at that time that it leaked? That's how you were treating Miss Reed? Yes or no?
Yes.
And then you followed that up just to make sure you cleared up any mistake about what you meant with leaks poo, correct?
All
Objection.
right, so I'm going to strike that. You
I
can
can't.
get this in, but do it the right way, Mr. Jackson.
You followed that up with the phrase leaks poo, didn't you?
I did.
Again, another reference to Miss Reed's medical issues and medical conditions, correct?
Correct.
Specifically focused on her anus, correct?
In reference, yes.
Were you aware at the time that you wrote this that Miss Reed had suffered a colectomy
embarrassment?
surgery, very serious surgery?
I was not, sir. No.
Were you aware that she had had
I would
10
want to testify.
surgeries in 18
About
months,
leaky balloon,
several
not-
years prior?
Mm-mm.
10.
Nope.
I was not aware of that.
Ma'am.
Were you aware that she had serious medical issues, gastrointestinal medical issues that she suffered with, she was a victim of for years? Did you know that?
Objection.
Sustained.
But you decided
I work
Are you
at the
gonna take another
healthcare
shot
field
at
and I'm
her?
disgusted.
and talk about her anatomy.
1 second, sir. Sorry.
We're studying Carrie
You just, I'm sorry.
Karen Reed. Don't come for me. Torta pounder. Karen Reed. No, it's not funny. You're right, Natasha. It's not funny. People have health conditions. He's disgusting. Pooper Proctor. It's nothing to be ashamed of. I work in the right. Like, it's a whole thing. But my whole thing is like the fact that you're texting about it. You can even get a fake number. Like, those are my things. It's like when you work in law enforcement, you get so caught up in the power of it all, right? That you think you can text these things. Like, you can do many things across my eyes. But like talking like this is just no. You can do many things. I can look past it, a lot of things, but this
You
to me,
decided
like,
that you were going to take another shot at her and talk about her anatomy.
I'll never get over this
as
first
a
trial.
balloon
No.
knot, correct?
Objection.
Sustained.
At this point, Trooper
balloon
Proctor,
knot?
Miss Reed
So
was just
degrading.
reduced to a punchline to you, wasn't she?
Objection.
Sustained.
Well, you weren't done yet. This chat doesn't end yet, does it?
No, sir.
It's just gross to talk about people like
Let's
that.
skip to
Especially the medical.
2543.
I'm just sorry. Well, I'm not sorry, actually. Not at all. I take that back.
On the same date, February 2nd, 2022, about 4:15 p.m., a person by the name of Whitey wrote, "What are you guzzling on?" Correct?
What I'm saying is from Pooper Proctor, from law enforcement, these are not things you should have said on your work cell phone. Or maybe any account. Maybe get a fake number. I don't know. Telegram. Telegram it up like Stephen Stern's pig vomit. I don't know.
Yes.
Figure it out.
And you wrote,
Don't lose your
nothing,
job over it.
writing a
Or
warrant.
maybe do, because you're
Is
a
that
piece
right?
of shit.
Correct.
Whitey then shares some sort
Oh,
of a video.
Proctor.
Correct?
Yes.
You remember that video being of the
But I paid
1980s
for
band
him.
Warrant?
I don't recall the video he sent.
0095 laughed and then wrote, "Wait, why does her asshole leak?" Correct?
Yes, that's what he wrote.
And then what did Doc write in response to that?
Objection, Your Honor.
Yuck.
The objection sustained. I'll see it. Sidebar, take that down, please.
Yuck. You're done. Yuck. Yuck. I'm in the medical field and I'm in school to be a doctor. Talking about someone like that is just nasty. Especially patients. My phone just fell down.
Objection.
Did you testify? Let's take them one at a time. Did you testify under oath, same oath you took here today, in a former proceeding in February of 2024, that you did not know and did not have any relationship with members of the Albert and McCabe families? Did you?
I haven't had a chance to review those minutes. I've only had one opportunity to, and that was a couple months ago. So I would want to review those minutes in order to answer that.
I don't judge you. If you like Pooper Proctor, so be it. I don't judge. I accept whatever you want. I do. I'm not gonna sit here. That's just my opinion. It doesn't mean that I'll judge you based off of what you think of Proctor, but will I question it? Maybe. But will I judge you based off that? Not necessarily. I think we all have different perspectives. We all have different mindsets. We all have different brains. We all have different feelings and emotions. I don't know. I'm just saying, if you support Pooper Proctor
accurately,
You can't remember how you testified, whether or not you knew or had relationships with the Alberts and McCabes?
Objection.
Sustained.
As you sit here right now, you need to refresh your recollection.
Yeah,
You can't
Natasha.
remember what you said.
Objection.
Do you remember what you said?
during that proceeding, no.
American Psycho just heard.
Would it refresh your recollection?
I'm
if you took a look
American Psycho. Yeah.
at those grand jury minutes.
Yes.
Someone tell YouTube I'm the American Psycho YouTube.
What page, Mr. Jackson?
This is page 01563.
Mhm.
Tell me, I have just a moment, Your Honor.
Yes.
Two different. Yeah, we're all over the place tonight. Welcome, Melanie.
Yes.
I'm sorry.
If you'd review that and look up when you're finished.
We need to have a little moment. Yeah, a little personal moment, a little Melly moment. Natasha, come live with me. Melanie, you getting jizzing tonight? I've already had. No. Have I already had enough buzzballs? Don't worry. Don't worry. I got some Modelo's in the fridge.
You were asked the question quote, did you communicate with first assistant?
Yeah, I've been working long shifts. I've been missing y'all. We're having a little moment. Like, I missed you guys so much. Miss going live. I have so many cases to talk about. Yeah, no, 3. I was saying it was 2 buzz balls. Just kidding. It was 3. It was 3. It was 3, yeah. Yeah. So I'm gonna do what I want. Yeah, I don't know. I don't know how you guys feel about that. I hope we can work this relationship out. Yeah, no. So I've been working them long hour shifts and I haven't been live as much. And so yeah, I miss it. Yeah, I miss having a good time, Melly After Darks, true crime. Don't worry though. Don't worry. I'm not slowing down on the true crime. I have many lives already ready to go. I just haven't had the time. True story. Let's get back to Pooper Proctor. I think you had enough of Melly tonight. Get back to Proctor.
Assistant DA Beeland that you did not know and had no relationship with the Albert and McCabe families. You answered, quote, to the best of my recollection, the same conversation took place with everyone I talked to about this.
I'll say in your world.
Answer.
You mean mouth to mouth?
It's the facts that I shared with everyone. Question, meaning you told First Assistant Beeland that you didn't know, didn't have a relationship with
Objection, Your Honor.
members of the Albert and McCabe families.
Oh, no.
Answer, correct.
This is turning into
Yes,
a
that's
whole
true.
ass
So your
party
question is
tonight.
whether he said this?
Correct. Whether that's his testimony. Do you recall that?
Yes.
And that's your testimony
Karen Reed
that you, in
goes Melly After Dark.
told members of the DA's office that you did not know and did not have a relationship with the Alberts or McCabe's. Is that right?
I did not know the McCabe's. I don't know most of the Alberts, and I have little to no relationship with Chris and Julie.
Lies. Lies Pooper.
So that's what I meant by that answer.
Well, the question wasn't, did you know most of the Alberts? The question was, did you have a relationship
Get ready,
with,
baby.
or did you know the Alberts? And your answer
I live
was
on the coast.
no.
No, I don't have a relationship with the Alberts.
Coast.
Or know them.
Hot coast. Ocean.
I don't know the McCabe's. I don't have a relationship with the Alberts.
So you do know the Alberts, correct?
I know some of them, Julie and Chris.
And Colin, correct?
Correct, and Colin.
And you knew the Alberts when you
You
gave
knew
this
Colin.
testimony in February of 2024. Is that right?
Yeah, they asked if there was any relationships.
And let's try this again. Meaning you told First Assistant Beeland that you didn't know, didn't have relationships with members of the Alberts.
Who, me?
And members of the Albert and McCabe families. Answer, correct.
Mm-hmm.
Was that ambiguous in your mind?
The way I interpreted relationships was basically being like friends or, communications, frequent communications. That's how I interpreted
Well, that might have been a good time to pipe up and say, well, I know Chris, I know Julie, and I know Colin, correct?
Objection.
Sustained.
That might have been a good time to answer the question. I know these 3 individuals.
What I'm saying is I don't care.
Right?
Objection.
Sustained.
But your answer was one word, correct, right?
Yes.
You further testified that you never have gone to any supervisor at Massachusetts State Police to disclose even a potential conflict of interest in this case that you might have, correct?
Correct.
You guys
You
ready to
indicated
turn this into a Melly After
The
Dark?
needs never come up. Is that right?
Correct.
I might need to get
You
back.
also told ADA Lally
After
that
members
you, quote, did not have relationships with, did not have relationships or know members of the Albert or McCabe families, correct?
Correct.
And that's just not true.
I think you gotta
is
listen
it?
to Bad Baby tonight.
You did know, you do know members of the Albert family. Isn't that right?
It's different from having a relationship with people.
But what about part of the question? Did not have relationships or know members of the Albert or McCabe families. How about that part of the question?
Well, that's
Mo, tonight it was like a true crime live. It turned into Melly After Dark, and now we're just getting into trouble. So, like, glad you made it. We miss you. But yeah, be prepared. It's my channel. I can't. I can't do it. I can't pretend to be something I'm not. I really can't. So if I want to drink up on my life and have a good time, I'm gonna do it. But we missed you. Mo's like, great. We're gonna listen to Bad Baby tonight.
Slumped in with the
That's what last
McCabe's.
night.
I don't know the McCabe family,
I'm
sir.
here for
I
it.
see. So what
Says
you
Mo.
did, Trooper Proctor, is you dissected the sentence, and where relationships are concerned, you ignored that in terms of the Alberts because you don't have relationships. Where no is concerned, you link that to the McCabe's because you don't know the McCabe's. That's what you did?
No.
So it's sustained. You can ask it. You can break it down.
This is the old
I'm
child.
not sure I can.
Clearly.
I'll ask it a different way. How about if I just ask it this way? That was a lie, wasn't it?
No, absolutely not.
You stand by that testimony?
Yes.
That you don't know the McCabe,
Hey, Ken,
at the
I'm
time
not
that you
going.
testified, that you didn't know the Alberts or any members of the Albert family?
They don't have relationships with them.
Right. My question is, you keep going back to relationships. I'm asking you, did you testify that you didn't know them?
Objection.
I'll let him have it. Do you understand the question?
Let him have it, baby.
I
Let
do
him have it.
Chris, Julie, and Colin.
So if you were to say, I don't know any members of the Albert family, that would have been a lie, correct?
Objection.
Yeah.
Sustained.
A lie.
Your
Don't be
Honor,
lying.
this is the point at which I intend to turn to tab 3, and I believe we need to approach.
Okay. Jurors, feel free to stand.
Have you had enough of Pooper Proctor? Have you had enough? You're like, Millie, please. Are you guys ready for some music? I'm in the vibe. I'm going to grab another drink. Who on here is going to be like, oh my God, Millie's crazy. She's drinking on our... Don't come for me. Ken, I'm not sure if you're trying to talk shit or not, but nah. Trust me. If I had too many drinks up here tonight, this would be rated R. Explicit. Whoa, chill out. I'm just saying. We're gonna listen. Wait. We're gonna play. Don't worry, we're going back to Karen Reed. I'm on a Karen Reed kick. But if you want me to play something else, let me know. But don't come in here. Don't come into my channel telling me about myself. It's probably not the best for you. Okay. There's another Karen Reed video. Are you guys over the Karen Reed? I mean, this is a Karen Reed live. Okay, I want to watch this video about Karen Reed. Don't get mad just because I'm telling you how I feel. Don't get mad. Okay, here we go. Let's watch this clip from the hearing. I'm kind of over Pooper Proctor.
Tonight, they're gearing up for the Karen Reed murder trial, the sequel. This after her first trial ended in a hung jury last summer. Reed and her defense team attended a final hearing today, and with the bad taste of last year's mistrial still in the attorneys' mouths, the arguments over the witnesses and the evidence got very heated today.
We provided the discovery pursuant to the orders so that they would be held to the same standard. It's not an aberration. This is a continued pattern from the last trial.
Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor.
46-year-old Karen Reed is accused of killing her boyfriend, who was a Boston police officer named John O'Keefe, back in 2022. She allegedly, according to the prosecutors, hit him with her SUV and then left him to die in the cold. The charges are serious and salacious, but the defense is just as sensational. It's built around claims of police corruption and cover-up. Karen Reed, who's been described as America's happiest murder defendant, told our own Caitlin Becker today that she'll be ready for round 2 when the opening statements begin next Tuesday.
Do you feel different this time around versus last time?
I feel a little more tired, but I feel strong. I feel stronger every day.
For thoughts on the trial this second time around, let's go to my guest, Ronnie Estanislao. He was a juror on Karen Reed's first trial. Ronnie, thanks so much for being here. So you believe Karen Reed is innocent of these charges. Why?
We just didn't have enough of the facts. The facts that were provided to us in the testimony clearly indicated that if there was reasonable doubt, or it was clear that she was not guilty of certain charges.
So the first trial ended in a mistrial with a, quote, starkly divided jury. What was going on in that jury room?
The issue that we encountered is that we did not understand the charge, which was to deal with each individual charge separately, as opposed to looking at all 3 charges as a whole. So what we actually were convinced on is that the first charge, which is essentially second-degree murder, as well as the third charge, which was leaving the scene of an accident, we voted on, but we did not sign the document. And the only one that we were debating a lot on and deliberated for several days on was the second charge, which was involuntary manslaughter.
So basically, you're telling me that some of your juries, your jurors on the jury that you were on, thought she was guilty of manslaughter and others didn't.
That's correct. And that's the one that we deliberated on for several days. But the other 2 charges we were very clear on at the time, not guilty.
So you don't think she's guilty of manslaughter, correct?
Correct. I do not believe that she's guilty of manslaughter.
And you're a paramedic. What did you make of the injuries that Officer O'Keefe suffered? Did the prosecution's case make sense to you that Karen Reed hit him with her car and then left him to die in the snow?
It did not. The injuries were inconsistent with a pedestrian struck, as well as the damage to the vehicle was inconsistent to the severity of the injuries that he sustained, and there was a reasonable doubt that was created. Therefore, it was clear to me that she was not guilty based on the evidence that we were provided.
So for you, the injuries didn't add up. The evidence didn't point to her being the one who killed him. I want to ask you something, Ronnie, because you were in court every day with her in this first trial, obviously. Karen Reed herself has come under a lot of criticism for the way she acted during her first trial and for doing this documentary on Netflix. She smiles a lot. That's why she's been called the world's happiest murder defendant. Take a look at this clip from this documentary that just came out.
You're tired of it. You spent so much.
No, I'm not tired of it. I hate answering it because I feel like I'm being so scrutinized. Like, did she blink 3 times or twice? And did she like smirk or look to the right or down and up and left and whatever? And like, it just feels so fake, even though it's true. I rather like explain everything else. And like, I did not hit John with my car. Like, I can't make it sincere enough.
What do you make of this criticism of her? And do you buy into it? Do you find her a little cavalier about this whole thing?
I believe we're all human and we are all emotional, and therefore we can have some emotions and some expressions. I think it's hard, even for us as jurors, it was hard for us to actually have that poker face and have no expression, given the testimony and given some of the witnesses.
But you didn't find her distracting or inappropriate in court?
No, I think to me, she was a defendant and we were looking at the evidence that was provided to us.
Super quick, you think the second jury is going to be a hung jury too? Why?
I honestly think that we did our due diligence as a jury, and we couldn't get.
Okay, so I know this clip has to do with Kenry. Okay, so I feel like we're moving to different topics. I want to cover the Sebastian Rogers case. We're going to listen. Okay. Oh my God, we just turned into Kenry. Now we're going into Sebastian Rogers' case. We're going to watch the interview from Cluminati. I don't support the trauma channels, but I think it's important to listen how these parents talk when it comes to a missing child. So if you're not caught up on the Sebastian Rogers case, his parents, well, his stepfather, Chris Proudfoot, and his father, Seth Rogers, had like problems on the YouTubes like yesterday. They were nasty. I don't cover the Sebastian Rogers case here for a reason, not only because I used to mod for a lot of channels that supported the green team and then didn't support the green team. If you want to know why I don't mod for a lot of those channels, you can just ask me rather than just like listening to the bullshit. But I know that Chris and Seth did an interview or a live within the last day. And from what I'm hearing, it's pretty nasty how they both acted. So when it comes into terms of who you think is responsible for Sebastian Rogers' death, I don't know. Like you might not want to hear what I have to say, but how people talk and act on a platform like YouTube speaks volumes. It does. So if you're going to come on here and be nasty, I'm just saying, and if you have a missing child, why is that your priority to come up on here and talk shit about the other parent? There's so many things regarding the Sebastian Rogers case, and I've stayed away from it for far too long. But I'm not anymore. I feel like I can, as a true crime channel, I feel like I have the right to speak on it, and I have been following it from the beginning. So I pulled up the Cluminati interview of Chris Proudfoot, and then I want to watch the Seth Rogers for when he was on the lab. And I want to dissect it. I think it's important to realize how nasty some people are, right? And they have a missing child. And then there's all these people grifting on Sebastian Rogers. I'm shook. I'm shook that people even donate to those channels. Let that be a lesson learned. Don't do it anymore. Yeah, it was on the other night. I think he took it down. I'm not sure. I'll say. But let me know if this is a Chris Proudfoot interview, because I'm pretty sure this is what I got sent.
I'm good.
So I heard y'all were talking about what's going on, what's next, everything like that. So we stayed behind and
This
had a
Chris
little meeting with
Proudfoot.
the attorneys and a few other folks. And so you guys are kind of on the same path of correct, but there's a few things. So to help clear up the confusion about some things, today's
Not me
court
going
hearing,
there, baby.
they
I
were
got some
not
tea
granted
about this
a
case.
continuance, so it
I've
was
stayed silent.
moving forward. So it was going to be as a bench hearing initially. And when that happens, the defendant has the choice. They can take a bench hearing or they can request a preliminary hearing. And in this case, of course, they took the preliminary hearing, which when you do a preliminary hearing, you're basically
Could you
trying
give a quick
to
recap?
put together a probable cause case, basically. When the judge hears the case, which in this case, there was a lot of things going on. It was moved down to Judge McCormick from Judge Blanton because Judge Blanton recused himself. I won't speak on as of to why he recused himself, just because it's another deal. Judge McCormick then took over the case. We started all over.
The prosecution and
At
witnesses
that point, moved
testify.
forward. Judge
There is
McCormick
no defense
found
Addie involved.
I agree with that.
Oh my God.
so, but yeah, that's kind of where
This is Chris Podcast.
everybody's at with the whole thing.
Yeah.
But
I don't know. I mean, I think overall it was, I think she
My point is, why is any parent of a missing child coming on to these panels and being disgusting and nasty and foul? That's what I'm wondering. Don't mind me over here in my little true crime channel. I just want to know why you all are doing that. If you're concerned about your child being missing for over a year, why are you coming onto panels and being disgusting and using degrading words? I'm sorry. I can't do it.
think it went, you know what I mean? She's already done.
he had been charged with 6 counts. Those 6 counts had to be
Nah, I don't buy
argued
it.
in court,
Seth and Chris
and those are
Papa,
the only 6
suck on
counts
it.
that
No,
were
no,
gonna
no.
be
Y'all are
argued in
shady.
that court at that
I don't want
time.
to hear
Now,
anything about it.
later on, who knows?
Both parents
there-
here are
that's-
responsible. Oh my God, don't come for me. Seth, you were the responsible parent who was allegedly watching him and had custody over him. Chris Papa, we know you were abusive and you're a violent fuck because we can see it in the video. Same with you, Seth Rogers. At the end of the day, both of you were unfit people to have Sebastian Rogers in your case or in your care. And this case has turned out to be something else. So that's what I think about the Sebastian Rogers. And I welcome all the haters. But these 2 interviews that I saw with Cluminati and then the lab, where they're both being disgustingly nasty, speaks for itself, and I don't need to hear anything else. Unless it comes from law enforcement, I don't want to hear the bullshit.
to the ADA or the DA's office and the sheriff's department,
Jason
whoever
God,
else is
don't be
involved.
here
That's for
being
them
weird.
to decide that, not us.
You don't
Yeah,
know
because
me.
there is
so
always the, you know,
you can stop
possibility
in your
of
comments if you're trying to be
adding more
offensive.
charges. We were talking about that on the way home, right? And the fiance said, you know, if she's like found guilty of those, they absolutely can then go back and everything that
Why are you
she's
on YouTube
done,
talking shit,
if it is
Seth and Chris
considered
Papa?
a charge like
Guilty
the ones that have already been
in my book.
settled.
No, actually, they won't. So the
They
way
won't
it
do
probably
that?
no, it probably will work at the grand and it after the grand jury, if they get an indictment and they go to arraignment. Once you go to an arraignment, your arraignment
No, I
will
don't
list
cover.
all the
I
charges you're
haven't
being
covered
charged
the
for.
Sebastian Rogers case because I used to mod for the Green Team, and there was a bunch of controversy over that. Regardless of what my opinion is, the fact that both of these parents are kind of being disgusting and dropping vulgar words says enough to me about the atmosphere and the environment he was living in. I don't need a professional to tell me that. I have a degree in early childhood development, and both Chris and Seth are responsible. Same with Kitty Prophet.
All the way
So
out.
the 6th.
Uh,
Or they
I think
could add.
I think it's May 23rd.
No. I'm saying it'll be for those 6 charges.
Yeah, I'm not here. I'm not on anyone's team.
No, well, that's what I was saying.
I give no
I
fucks
guess I
about
wouldn't
fitting
explain
into the
it right,
YouTube
but that's
community.
what
I
I
don't
was
care about
saying.
the Green Team. I don't care about this person. I don't care. Where Sebastian should remain the topic of the case, and so many channels have done they've done the opposite of that and grifted off of it. And I'm so horrified. Like, I just come on here to talk about true crime, but I'm horrified that some people take advantage of viewers like that. And I can name, so I can drop. Don't get me started. I think all of them are responsible. Katie Proudfoot, Chris Proudfoot, and Seth Rogers. So I'm not here defending Seth Rogers. No. Don't get twisted. And I don't care for the green team. I used to mod for one of those channels. Yuck. But I'm going to get into the drink
Right,
as we
there's
listen
always
to
the
this interview.
possibility to add onto.
Yeah, I'm not here
what she's
to.
been like this
I'm
whole
not here to
time,
get beat
right?
on good
It's
graces.
Yes.
Anyone.
So
Yeah.
yeah, I see what you're
I
saying.
don't
Yeah,
like
as
fake
of right
ass
now,
people.
there's at least 6 charges that
Fake
she's
ass
looking
channels.
at, and like I said, there could be more or could be less. You know, and of course, you know, in that 90-day range after the arraignment's done and discovery and all that, you know, there's multiple things that can take place in the middle of there. There, you know, if the district attorney's office
No, she
offers
went to bed.
a deal, I mean, that's also an option that could go forward. Who knows? I mean, it's definitely outside of our scope, you know.
Can I just say, they took a video of me in my overalls and they're saying, "Look what she's wearing."
Said, bring back the true crime,
Hold on,
talk
hold on,
about the
please.
case. You know, do
He's fine,
things,
God.
talk about the case.
Yeah,
Don't
no.
go
No one's paying me.
dumb and
Other than
stupid and
YouTube.
start filing a bunch of
Yeah,
things.
no, I
and,
give no fucks.
I don't know.
And people can expose me all day
Yeah,
long, baby.
I
If you want to see my nalgas, just tell me.
I did
I'll
tell
show you.
them that
That ain't no problem, baby.
at one point her attorney said that she was a journalist or reporter or something, and you said on the stand she's a YouTubist.
Yeah, I said she was a YouTubist.
Why is Chris Proudfoot going on to these
And
channels
I don't know if that's
talking
terminology for somebody who
like
I
this?
mean, I don't know. I've heard it YouTubist. I've heard content creator, whatever. She is not a journalist.
No, I welcome it.
I mean, most journalists have credentials.
Entertain me.
and
I got so many
credibility.
stories for y'all. We haven't even dug into like
Doesn't seem so in
Mellyverse,
this case.
really. We're just getting started.
Yeah, I don't know. But
You've only
I
seen
mean,
like 10%.
the judge obviously found probable cause was proved.
You've only seen like
and now
10%.
it's
This
up
is
to
nothing. If you thought this was
grand
too
jury.
much,
So
grab onto your diapers, baby, because
we'll see what happens, I guess.
Yeah, I mean,
why is Chris Proudfoot talking
you
like
know,
this
I mean,
again?
it's going to be interesting. Shocking, I guess. Some of her supporters didn't show up.
I very much talk
to
my
this
shit up
interview, so
here
I
because
don't
I
know
very much dealt with it and
what happened
learned
there.
with it, and I got no shame.
Yeah, it was
Got
kind
no
of
shame
light
in my game.
on that side today.
Yeah. Normally, I think we see the E's, don't we?
Yeah.
Didn't see any
Where's
of them. They weren't
Sebastian
there.
Rogers?
So that was kind
Does
of
anyone care? Just wondering.
Nope.
Just wondering.
Just
Just wondering.
another.
You don't want me to yell at you because all I see is Seth Rogers and Chris Proudfoot coming on YouTube channels and grifting and making money off of it. Whether you think they're innocent or not, I don't care. The fact that they come up on panels and talk disgusting like they did in this interview, which you haven't even watched it all. If you have, good for you. If you haven't, we're gonna watch it together. I don't even know that I can get through it. It's just like it's below me in my energy levels, but you don't want to speak to law enforcement. You don't want to give interviews, but you're going to come up on like a YouTube panel and talk your shit. Is that what it is? Oh, okay.
Person, but yeah.
I agree with Twitch.
Snazzy Trinkets Jewelry had a great new name for
I
individuals.
didn't know it was a
like
horror live stream.
Penny,
18 God.
True crime.
You better watch out. I might pop up from under your bed.
Be careful with those words.
I thought it was pretty good,
I'm
actually.
gonna tell 18 God.
Well, it's pretty good.
Chill
But
out.
certain words are triggering for some folks.
that's-
Extremists could be a very triggering word. I would just not very good words. You know,
Touche.
just like
I'm sorry.
abusive and
You don't like my channel, don't watch it.
yeah, yep. I mean, like I said, there's a difference in freedom of speech and getting yourself in some possible hot water.
Yeah, for sure.
This is a step
I think a lot
parent of a
people need
missing
to
child.
remind themselves that yes, you have rights and you have ways of doing things without getting in trouble.
What about
Doesn't mean you can,
Sebastian's rights?
to the
What
word
about
you can
how he
own
was
your
living in
narrative.
an unsafe home environment
Yeah.
from both Chris Proudfoot and Katie Proudfoot's and Seth? That one of them, it's just not one party that's here to blame. And I haven't spoke up on this case because I know a lot of the people involved with this case. But the fact that you come to a YouTube platform and talk like this, I got nothing nice to say. It's not that I'm knocking people using their platform. It's just that why are you coming onto Cluminati's channel and talking like this? Disgusting, foul, degrading words. Both from Seth and Chris. And then you want us to defend you. And then people are grifting. They're grifting and people are donating. Why? I'm shook. I'm shook. I can spend hours on a deep dive, days, even weeks on a deep dive to have channels like this just overcloud the real meaning of content. Like, am I offended? Sure. Do I feel for Sebastian? Yes. I feel like he was failed all the way around. Katie, Seth, and Chris, you all are responsible. And Seth of all people. Oh my God, don't come for me because I'm saying that he has some involvement. Seth has a temper on him, and I don't have to look past my degree to know that there's some issues there. And you can judge me. You don't have to like, you can unsubscribe if you don't like what I'm saying about the Sebastian Rogers case right now. It's disgusting what I've seen on this case in the last few days. And I'm shook because he's been missing for so long.
No, I
I have
agree.
no idea what happened to him.
And I will say, like, I honestly thought that all of the attorneys today did fairly well. Like, I think even her attorney, right?
Oh
He,
yeah.
he brought a really decent argument, you know? But I think my favorite kind of volley between the two of them was when the defense was trying to
No,
like,
18 God. I said if you
prove,
want to come here and talk
okay,
straight, you'll get.
so someone sent them a message with a link in it, right? But you have to click it, and then the attorney or the DA or whatever that guy was for the state was like, that would be no different than them mailing her a letter and her having to open it. And it's like, you can't argue that, you know?
No, I wouldn't. Even, I'm not gonna lie. I wouldn't begin to try to argue. But both of them had very good points. However, I think the state had a much better point that freedom of speech is when you want to vocalize your words, not you driving 12 to 16 hours up here to trespass, stalk.
I don't need
She
someone
did
telling me
stalk.
my amendment rights.
She was already told where his
not that-
parents were and things like that, and then you were Cash Apped or Venmo'd or whatever $50 from TikTok Tony or Tony Mathis saying beat up the B socks is like, okay, like that's not freedom of speech. That's you're insinuating potential violence. You're insinuating things that you shouldn't be insinuating.
You guys are insane. My chat is always off the chain. I'm sorry. You probably can't see it, but
No, I can't. Sorry.
well, I mean, camping outside of someone's job and
well, yeah, and you follow me to the campsite and you videotape it, and then you say you're gonna crawl up my ass so far that you'll see palpable palpals or whatever the hell she said. That's
Okay, I'm
not
gonna grab another drink.
freedom of speech.
You guys
That's
okay with that?
threats.
Tell Chris Broadfoot don't come for me.
It's a whole different level. But whatever. I mean, it's her business. I mean, I don't see how she can't say that's not like she's not stalking me, but you went to my house and you used night vision goggles at 3 a.m. driving past my house. Like, okay. Then you want to go all the way to Memphis and you want to stay in a hotel that's like 6 blocks from my job site. And you drive down to my campsite. And you've been down there not once, you've been down there 2 or 3 times. So it's like, and then you also had somebody else down there trying to scope out my campsite. You had other people out there trying to let me know where they go and where they hang out. Well, that is inciting things and causing people to do stupid things.
Well, it's kind
And that
of
is
funny.
indirect contact, by the way.
I do agree, right? And I mean, it is funny that there is this sort of like I can't imagine a situation where I would ever feel like I'm entitled to tell another person, "Hey, let me know where
I
they
can't.
go. Let me know when they leave their house. If you see them out, send me a picture."
I can't even handle these comment channels. I'm trying to watch this interview because it's wild. My soul can't do it. I like literally don't have it. Do you guys want to keep watching that? You?
Like I think that's creepy. You know what I mean?
Oh yeah, absolutely. But she's also made videos where she
can't.
says in her videos, "I'm talking directly to you, Chris Proudfoot,
right?
Or you, Katie Proudfoot." Like you're directly speaking to us, and you want to tell the courts that you're not.
Right.
Man.
Like I agree because that's what I was sitting there in the courtroom today thinking. I'm like, well, I know for a fact that I've seen videos where she has purposefully said, how do you feel now? How do you like me now, Chris? Right? You're asking me a question. You are absolutely addressing me.
Oh,
100%.
So
I don't know.
Yeah, I can't. I'm sorry, I can't. I just can't do it. I just can't do it. I mean, we can have a little one-on-one in the meantime. Like, ask me anything you want right now. This is your chance. What do you want to know? Moment of truth. Here we go. Before I go to bed, ask me. I can't do the comma. I can't do it. That's how I feel about the Sebastian case, though. I do want you guys to watch. Pandora's like, here we go. What? Here we go. Truth or dare, you dudes? LOL. Me and Smog Dog. Wait, you're saying that you're kicking it with Smog Dog, or we're all gonna kick it? You and me and Smog Dog. What are you saying? Okay. I have another case that I want to talk about. And I'm shook. Let me pull it up. I have to sneeze. I have to like, I don't want to sneeze in your ears. I don't want to be rude. Okay, wait. Before we talk about true crime, I need to know 2 things. Have you watched Ozarks on Netflix? Thank you. Have any of you seen that? Seen the show? Ozarks on Netflix? Okay. That is one of my favorite shows ever. If you haven't, get your little cute ass to bed tonight and watch it and think of me. Do you know what I mean? Like, I love that show. I can watch it over and over and over and over. I think I've seen it a total of like 6 times. I'm so glad we're on the same page. I like having these conversations about things we like. Cheers. Not me being the bad influence. Like, people are like, oh my God, there's a true crime girl who's always drinking on her life. Shut the fuck up. I don't want to hear anymore. I don't want to hear anymore unless people got something to say about themselves. Oh my God, I have to screenshot what you guys are saying right now. Mayor of Kingstown, you should watch Suits. Okay, I'm going to play some music in the background while you guys... I haven't seen any of these. I'm not from Las Vegas. No, I'm not. No, I'm not. Absolutely not. I'm watching The Happy Face Killer on Netflix. Okay, one of my mods told me about there's a new Richard Allen, or not Richard Allen. Oh my God, I take that back. Not Richard Allen. The Lisk case. Wait, I'm missing it. Check out Mayor of Kingstown. I love Ozark. The Ozarks is one of my favorite shows. Baby, I can watch that all day long. I probably know a lot of the words. It's on Paramount. Okay, you want to know what show is really good too? On Apple TV. I love it. Do you guys have Apple TV or no? I know you can do like a free trial with them. Presumed Innocent. It's an older show and it used to have different actors or whatnot, but the new version on Apple TV, don't get me started. I'm one of those people, like, once I watch a show, like, I want to watch it like 742 times. You know what I mean? Is that like OCD? I don't necessarily know that that falls into the category of OCD. I get obsessed with these shows. I love Ozarks. Presumed Innocent on Apple TV. If you haven't watched it, please watch it. If you don't have, if you have an iPhone, you can do like a free trial. Yo, girl, got the hookup. Yeah, I don't have HBO Max. Do I need to get it? I don't even think I can play it. So I got struck by Netflix because I played Gabby Petito. I'm so sick of it. These other channels striking other channels. It's so petty. Well, Netflix is not just like some other like small channel. But they gave me they tried to give me a striker warning on the Gabby Petito live that I did because the body cam footage is now in the Netflix documentary, but they fucked me over because the body cam footage, that wasn't the first time it was on Netflix. So I had to file a dispute. Like, can someone tell Netflix to get off my ass? Like, God, someone tell Netflix to chill. Gabby Petito was far long existing. That was an existing case before Netflix even came up with the documentary. And by the way, I watched the documentary. Now I'm just rambling about random things. I watched the documentary and I have so many questions. I don't know. How did y'all not watch the Gabby Petito documentary? And I had so many questions, I think, than I did before the case or before the Netflix went in on the case. Like, I have so many questions. We're still deep diving that too. Like I said, I have like 17 lives ready to go. I just haven't had the time. It's sad. Yeah, I work in the healthcare field, so I've been working really long hours. But I'm hoping this weekend we can dig back into Gabby Petito. But like I said, there's so many questions, and I'm not here to knock the parents. I'm not here. Whatever we see in the documentary is like one thing, right? But like, I don't know. I guess we all have different parents and different experiences. But like, if I was trying to leave with my boyfriend like that, my dad would absolutely not have it. He would probably have someone. I don't know. My dad would not let me leave with my boyfriend. Even now. Like, if I try to leave the state or the country with a man, he would absolutely not be okay with it. And there's just a lot of questions about the Gabby Petito case that I have. And it's such a sad case. But anyways, I watched the documentary. I wasn't very impressed. I know everyone was like, oh my God, it was so good. Not impressed. Melly was not impressed. I'm not impressed. I'm not. What about the United Healthcare CEO murder? Luigi? Yeah, someone tell Luigi to hit me up. Yeah, I don't know that Luigi is guilty. Or is Luigi guilty? Has anyone looked into Luigi's past? Like how his parents owned a bunch of care homes and there was allegedly a lot of reports of fraud. Do you guys know that about Luigi's family? And how like maybe he was like I know in Syria they do a lot of like undercover FBI shit, CIA shit. I just question a lot of things with the United Healthcare CEO thing. And I work in healthcare. Is it the best field? No, absolutely not. It's just as corrupt as the Karen Reed cases. Is Luigi Mangione guilty in my eyes? I have questions. And the whole report with like the cops saying that, or the cops being called after he ordered the food. Wait, does that make sense? I don't know. But if dude has a manifesto, the police footage is only the real in-depth look at Gabby Petito. The police footage speaks for itself with Gabby Petito. Jason M. I'm not a paper pusher. I didn't say that I support it, and I didn't say that I don't support it. Chill out. Just because I work doesn't mean that I'm pushing anything. I worked in big pharma my whole life. You never saw me pushing anything like that. What I'm saying is, do I think the CEO deserved to be killed? No. Do I question what was going on behind? Yeah, I do. I question a lot the people who knew what he was doing. Yeah, I don't get it. See, I don't think he's guilty, but I've also not followed the case closely, so probably shouldn't say I'm open. On the Luigi, yeah, I haven't followed it closely, but I do know I looked into some things with I did look into that. I did find out that his parents owned a bunch of care homes. And there was like a bunch of fraud. I don't know. Don't come for me if you're watching Wade Wilson content. Not anyone in particular. I'm just saying, like, Luigi can be just as innocent or not as innocent as you think Wade is. And we still support Wade watching all the phone calls. There are unstable people in this world. Hard to trust anyone. Yeah, no. Insanity coming up. Yeah. I wish I could watch Ozarks on here. Oh my God, I would love to have an Ozarks watch party. Oh, I did want to watch this. I covered the Jesus Monroy, who killed his pregnant girlfriend. I don't know. It's probably been like 4 months. Guilty of what? Jason Bateman. No, I'm guilty. Yeah, I'm guilty. I'm guilty of coming up here. No, okay, Jesus Monroy killed his girlfriend who was pregnant. Do you guys remember this case? I talked about it like, oh my God. Okay, so when I first started my channel, I talked about Ashley Bocanegra case. I did a deep dive on that. And then I covered Sandra Birchmore. And then I covered the Jesus Monroy case. Not Jesus Monroy. That's not Mia Campos. Those were like the first 3 lives I did ever on my channel. I know, and it's probably not impressive, like the quality or what I was doing like during those lives, but actually, they're pretty good. I would watch them. But I did cover the Mia case, and there was a shocking ruling in her case, so I want to play that. It's like a 10-minute video. Do you guys know how I'm talking about? Mia Campos and her baby daddy murdered her in the forest, and he was out on bond. I have nothing nice to say about that. After this, you're going to go Nate. We're just playing random clips. I got
from the start. He was never around. We always had to tell him to do something. I guess that's just the
How
life
did
of a
he get
deadbeat.
out on bond?
It's hard to imagine what Mia
He
Campos is
killed his girlfriend who was pregnant, and he was out on bond, and then he had just a hearing. Don't even get me started.
family is going through as they come face to face with her alleged killer.
Every morning I went to her room to say good morning, my beautiful daughter. Now I go to the cemetery to tell that I miss her.
Mia's body was found in the woods last summer after her family made the devastating discovery. Now they're back in court as her alleged killer hopes to get out on bond despite objections from both Mia's family and the state.
The state's position is that the defendant is a flight risk, a danger to the community, and likely to commit additional felonies, and a risk to intimidate witnesses if he's released.
I'm Elizabeth Milner with Law and Crime. Mia was 7 months pregnant when she was killed. Her ex-boyfriend, Jesus Monroy, is charged with her murder. Now, he was previously released
7
on
months
bond.
pregnant.
Then more charges were tacked on. He was rearrested, but
She
now
was found murdered in the forest, in the woods. And her baby daddy was the last one, Jesus Monroy. I'm pissed about this case.
he's hoping a judge will release him on bond once again.
Oh, man.
The state also believes that he is a danger to the community.
Why was he out on bond?
A 15-year-old girl got her pregnant. We heard from all 3 witnesses, Mr. Alexis Campos, Edward Campos, and Miriam Zarata, the mother.
He killed her.
He
killed her like a year or 2 ago, and he is out on bond. Because I first covered this in August when I first started my channel in 2024. He got out on bond, and now he has another hearing. I don't even know why he's out on bond, because he was found near the body. Like, he was like trying to cover it up. And the family believes that. And he was saying that he didn't want to be a father prior to the murder. So why is he out on bond? 7 months pregnant. I'll never understand these things.
Moment that Mia found out she was pregnant, he took steps for her to try to
Have a good night, Natasha.
from buying her the Plan B pill, which she did not take, telling her to get an abortion, and telling the family he wanted an abortion, that he was not going to take care of the baby.
They present evidence to the court and say it's my client, and it's not. It's not my client. He's not
Sad.
running around. His cousin testified to that. There's no evidence of risk of flight. Zero. In fact, there's an abundance of evidence to the exact opposite of that. He is a guaranteed person to stay and submit to the courts.
I'm sorry, 7 weeks. Or 7
Danger
months.
to the
not 7 weeks.
community. They presented no evidence of that other than the allegations merely contained in the indictment.
It was a packed Georgia courtroom last week when Mia Campos' alleged killer, Jesus Monroy, appeared in court. Mia was just 16 years old when she died. Her ex-boyfriend, Jesus, was 20 at the time and was the father of her unborn child. If you've been following the case, you know initially he wasn't charged with murder, just providing false statements. But those charges were upgraded. So now he's facing malice murder, felony murder, feticide, and aggravated assault. But then more charges came. In between him being charged with murder and aggravated assault, Jesus was granted bond. It was a surprisingly low bond given the charges, only $50,000. So he was out of jail with an ankle monitor. That is until February, when a grand jury indicted him on new charges like statutory rape, child molestation, and enticing a child for indecent purposes. And those charges came on top of the murder charges. So he's back in custody. He was out of jail about 6 months before being taken back to jail. At his latest court hearing, though, the state urged the judge not to let him out, sharing new details about the months leading up to Mia's murder.
This defendant molested a teenage girl, got her pregnant, and then killed her and her unborn baby. The defendant committed multiple unlawful sex acts on Mia Campos when she was 15 and 16 years old. On December 16th of 2023, the defendant picked up Mia and took her to a secluded location off Classic Drive in Snellville and Gwinnett County. He parked his truck. He then proceeded to have vaginal sex with Mia in his truck. At this time, she was only 15 years old and he was 19. This was one of several child molestations that he committed on Mia.
I know it's like different with people's like morals, experiences, culture, like dating someone who's 19 and 15. I know it's a crime. Like, I know that's a crime. It's called like rape because they're underage. But like in some cultures, it's normal to date someone that much older. Yeah, I think 15. I'm not saying that it's okay that he killed her and got her impregnated, but I don't think the age gap is that concerning. I know she's a child, but I mean, I think it's concerning because of what happened, but I don't feel like necessarily, I guess, depending on how you grow up and your parents and your morals, maybe dating a 19-year-old is very much out of the element. I grew up in the Hispanic culture though, so I think dating someone even 4 years older than you, that wasn't like a really big deal. I know it sounds bad. It's not. I just think it's different for everybody. But he got her pregnant and then he killed her. So I don't know. I know it's statutory rape.
2024, Mia found out she was pregnant. At that point, the defendant encouraged her to get an abortion. Later, it was learned that the defendant also bought Mia the Plan B pill to end her pregnancy and made numerous attempts to get her to abort the baby. A conversation was had between Mia's parents.
I didn't know that part about the Plan B.
And the defendant's parents. And at that point, Mia's parents agreed not to report the child molestation to law enforcement if the defendant agreed to continue to help support the baby as well as support Mia by taking her to doctor's appointments and other things needed for her pregnancy. However, that did not happen. On July 14th of 2024, about 10:30 p.m., the defendant lured Mia out of her Loganville home where she lived with her parents and her older brother. The defendant told Mia he would take her to Quick Trip. She'd like to go there to get ice and snacks. And she was 7 months pregnant at that point. Mia texted a friend that the defendant was making her walk to the entrance of her neighborhood when he came to pick her up, rather than come all the way to her home to the driveway to get her. Again, it's 10:30 at night. She's a teenage girl and 7 months pregnant, but he still made her walk to the neighborhood. Mia texted her friend that she was scared. This was the last communication that Mia had with anyone.
The prosecutor explained Mia never made it to Quick Trip.
No,
The medical
although
examiner wrote
it's-
whoever killed Mia applied pressure to her neck.
Like, if I dated someone, but I don't know. Maybe we should have a million dad conversation up here, but like, I wouldn't say it's like abnormal, but for me, if I was a parent, I wouldn't be okay with it, personally.
And killed her by asphyxiation.
We ruled that her death was a homicide. The autopsy found also that the baby was healthy and a viable fetus. Further investigation shows video footage shows the defendant did leave his home to pick Mia up. When Mia did not return home that evening, which was shortly after she left to go to the Quick Trip, her family and friends started calling her and texting her, and it was unusual for Mia to not respond. That's when the family became worried. Mia's brother and her friend were able to locate her cell phone using the Life 360, an application that tracked her location. That app showed that Mia's phone was in the wood line near Stevens Road in Loganville, which was not that far from her home. Mia's family then contacted the defendant's family. In this regard, both families then went to look for them. Mia was found dead in the woods shortly later. Her eyes and her face showed fatigue.
Anyone who kills a pregnant woman at 7 months, that's diabolical. I won't be able to comprehend that.
Hemorrhaging, which was a sign of strangulation and asphyxiation, and she was bleeding out of her nose.
Why? He didn't want to be a dad?
The defendant, Mr. Monroy.
If you don't want to be a father, don't stick your pee-pee in someone. Oh my God. Not beating.
Did not want Mia's family to
Stop.
tell police
Absolutely
that he was the baby's father. The defendant also told Mia's family that he never saw Mia, despite him actually coming and picking her up hours earlier.
After Mia's body was discovered, the state argues
Hold on.
Jesus deleted texts he had with Mia that day and even instructed Mia to delete her text and delete the deleted text from her trash folder. However, the phone records are pretty crucial. Jesus' phone pinged in the woods where Mia's body was found, even though he told police he was never there.
And DNA test
Oh, he lied?
got back today from the Georgia Bureau of Investigation that I'm handing a copy to Mr. Delpont
Hey, Kayla.
to show that the defendant is the father of Mia's unborn baby.
So again, this is a bond hearing. The state argues Jesus is a flight risk, and the testimony coming from detectives sheds more light into Jesus' behavior when they were investigating Mia's murder.
We approached the front gate. A gentleman in a green shirt came driving at a high rate of speed on the wrong lane of traffic, shouting warrant. We advised that we had a warrant and to open the gate for us.
Do you know who that gentleman was?
I believe it was the brother of the suspect.
Okay. Was the gate opened?
Not immediately. He made a phone call. While he made that phone call, the drone operator that we have above the structure advised us that the suspect had ran out of the main building.
Yeah, this case is out of Georgia.
And into a different building in the residence. Suspect's now running to the barn, which is his first stop. Goes inside for a few seconds.
Yeah. Wait. Yeah, it's Gwinnett County.
and then runs to.
It's Gwinnett County. Okay, so that's Gwinnett County. So yeah, Georgia. Gwinnett County, Georgia. This case is the same as the Ashley Bocanegra case that I covered, the first deep dive I did on my channel. Please go watch that. That will forever be one of my favorite cases, and I know her family too. I have some plans on that case coming up. But that was my first deep dive. Anyways, that case was out of Gwinnett County, Georgia, and this case is out of Gwinnett County, Georgia as well. If you haven't watched the Ashley case, please go watch that. I have a playlist. I love that case. Not like what happened. I love Ashley and her family. That's what I mean. But I love that case.
And Detective, do you know what was in that barn, if he put anything in there?
I didn't go and
And I will be at that parole hearing.
But you did eventually find him in that main house we see?
Yes. After we gained entry to the residence, we did find him in that house. We called him out and he came out.
But the defense pointed out, how could the investigator tell the person who was running on the drone footage was actually Jesus?
Now, as you're watching the video, you just testified that was, you said the suspect, but I assume you're meaning my client, Mr. Monroy.
Correct.
Jesus Monroy.
Yes, sir.
All right. How can you identify him?
Just through the clothes that he was wearing when he exited the house that we found him in.
Okay. What kind of clothes did you find my client in?
It was all black.
All black? Okay. I'm going to go back.
Please watch the Ashley case.
And because I had terrible.
We might have a whole live on the Ashley case here soon. Maybe even this weekend. I kind of want to do an after dark and like talk about it. I'm the only person. Well, I take that back. There's other channels that have talked about it, but I was one of the very first channels who had like the actual body cam footage and stuff. And I had it without being redacted. And I showed it on my channel too. The Mia Campos case or the Ashley case. The Mia Campos happened. So we're in 2025. If I'm correct, I'm trying to remember. I know he had a hearing in October of 2024 because I think that's when I covered it. But I think the case happened. I might have to look it up. Or maybe it was when I watched the hearing. Maybe it was in 2024. Yeah. So he had a hearing, I think, in October 2024, but I think the case, July 2024. I think that's when they found her body. July 2024. Someone correct me if I'm wrong. Because I know he had a hearing and he was let out on bond. And then he went back for another hearing. And that was, I think, rescheduled. And then I think this is the next hearing that he had, which he's still out on bond. So this guy, I don't even know if he has like papers. Not that that matters, but he killed this girl and he was out on bond. This makes me feel really uncomfortable. You know, like these people are walking amongst society.
I'm going to just zoom it in here for us.
I don't watch WrestleMania. No, don't come to me with your site.
The view in a little bit.
I don't watch WrestleMania. I'm not impressed.
Showing on the screen
Not
where
impressed. Not
you
impressed.
first see the person you have identified as my client.
Oh no.
Go ahead.
I haven't played it yet, but I just want to make sure that this is the right area.
What is the point of that? I'm just saying.
I'm gonna go ahead and play it.
Rather than wrestle,
You tell me when you see my client.
why can't people like fist fight? You know, like real G's.
Right there.
Are you aware that that house that's there belongs to my client's aunt?
No, sir.
You weren't aware of that, or it doesn't?
I just saw him run into that house, and that's where we found him at.
Okay, you came on the scene, asked everybody to come out of the house, and my client came out of this house.
First, we went to that house where he comes out of. Then we went to the
girlfriend
house that he
instead of
originally come out of. And
How
that's
do
where
you
we found
kill
the
someone
males.
with a baby inside them?
We'll pause this here. So that
You see it
house
in
where
true
that
crime all the time,
ran
but
into is the house that you said my client came out of.
Correct.
Okay. That individual wearing black shirt, black pants,
I can't.
white or light colored shoes.
Yes, sir.
Okay. Are you aware that when my client came out, he was wearing shorts?
I can't remember.
Were you aware that my client's cousin, Rafael Valdez, was wearing a black shirt and black pants that day?
I couldn't remember.
All right, thank you. That's all the
I'm
questions.
horrified.
Homicide Detective Julie Price was one of the many investigators also there when police executed a search warrant. She wore her body cam that day, and when she first spoke with Jesus, he was in the back of a squad car.
How we kind of like it, but I know it's kind of a shock when it doesn't happen, you know what I mean?
Why do they do that?
I didn't tell you you're not getting arrested or anything. Did I tell you what we...
The search warrant from my mom is something for my chicken?
Yeah, so we're just going to get a swab of your cheeks. So my case, I'm not quite sure. I'm going to assume it's for the baby. Okay? Mm-hmm. Yeah.
Stopping at 2106. And Detective Price, I know it's hard from here, but did he say, oh, I'm not going back to jail?
Yeah, that was his thought.
And either way, if I run, they're going to catch me. Is that what we heard?
But Detective Price's testimony and even her body cam being taken into consideration when it comes to bond was objected by the defense. So the defense argues Jesus's rights were violated because when the search warrant was executed, he was out on bond. And when he was in the back of the squad car, every statement made during that time period should be thrown out because he didn't have his lawyer with him. The state, meanwhile, argues Jesus wasn't under arrest and volunteered that statement.
But he was with the body. When they went looking for her, he was found. He knew where the body was and he threw his body over her to try to hide something. I don't know. I'm horrified by this. He needs to stay in jail.
Him at all about his charges, what he did, why he's there, what's going on, why he ran, did he not run? She did not ask any questions about that. The only question she asked was about the horses.
Statements made that a reasonable person would assume it requires a response or induces a response are the same way. And in that video, while they talked about horses for a bit of time, Detective Price talked to him initially about why they're there, who's in the house. We're sorry about this. It's about the baby. This is all about the baby. And then towards the end, says, starts talking about, well, we called you guys. We asked y'all to come out. We did all, and she's talking to my client directly about the circumstances that lead to what the state believes is an incriminating statement. Under these circumstances, it's just a violation of the fundamental due process rights of my client.
But the judge ruled to overrule the defense's objection. Yeah. His older brother, Alexis, says he still carries guilt for letting Mia meet up with Jesus that day.
Ever since that night, I've carried so much guilt because I was the last one to see my little sister alive. She told me she was going to the gas station with Jesus, and I just let her go. Just so that monster that sits right there can take her away from me and my family. Hearing my mother cry every night because her heart and the light of her life isn't here anymore. Just because Jesus didn't want to take care of my sister or his son. Ever since he found out Mia was pregnant, he didn't want responsibility and wanted her to.
Are you going to kill your baby mama and you don't want to be with her and have a baby?
Abort from the start.
I don't know.
He was never around. We always had to tell him to do something. I guess that's just the life of a deadbeat.
Elaborate.
Who gets what he wants and doesn't care about responsibility.
If you've been through it.
We spent Halloween, Thanksgiving, Christmas, New Year, my birthday, and my mother's birthday at the cemetery, crying and grieving over Mia and Sebastian. It breaks my heart knowing Sebastian couldn't
Sebastian
even
is a
see
baby.
the light or the world. His life was cut short, and his family, and Jesus and his family and friends just mock us and laugh at us like the heartless monsters that they are. Knowing that his friends were at my house visiting us and telling my parents, sorry for your loss, knowing they support him and his family just makes me so angry. I've carried, so much guilt for not trying to stop her. I've gotten tattoos in her honor, but the main reason I got them was mostly for pain. To get my mind off the fact that my baby sister isn't here anymore, just for a couple hours, but having to live in that house, passing her lonely room every single day, seeing her picture wherever I go, passing where she was killed every day to go to work and come back home, just makes me feel like I failed as a brother and uncle. Ever since Mia left this world, I've been so lonely. I try to surround myself with people I love, but it's not the same.
Mia's father also gave a heartbreaking statement where he said he was ready to be a grandfather.
But they took my grandchild away from me. He had no chance to see the light, and didn't deserve that. He was just an angel. Everything that I live from work, I turn to my house and I can see my daughter walking on the street when her belly. And I got out of my head and I can't get it out. I got this pain that I am going to carry for the rest of my life. I wish if I can see her and my grandson
I'm sorry.
one more time to tell them that I love you guys and I miss you. I hope one day we'll be reunited again. My life is not the same without them. I hope you understand the pain all my family went through, but the pain is still there before they took away from me. Every morning I went to her room to say, good morning, my beautiful daughter. Now I go to the cemetery to tell that.
Thinking about you, I'm like, where is she?
I miss
Go
her.
back in here,
She didn't know that what kind of person that he was, and the way he took advantage of Mia, because Mia was innocent and hurts me like a father losing the youngest of my family. And I don't understand the father or the child taking his son's life. He didn't deserve that. The way he killed him, he didn't just kill Mia and Sebastian. He killed my family because now we are on the same. We're not the same. In been 8 months that
come to bed with me? Question mark.
They are in gone.
Chill out.
And it feels like it was yesterday. I don't have any more words to feel this pain.
Mr. Campos, are you concerned about your family's safety if Jesus gets out of jail?
Yes.
The defense also had a chance to put up witnesses at the bond hearing, like Jesus' cousin, who delivered a huge blow to the state.
Are you in this? I still the screenshot here at 8 minutes and 49 seconds. Are you in this image?
Yes, I am.
What are you wearing?
I'm wearing black pajamas, white or light color
cousin.
black shirt, earrings, and.
Okay. And you said pajamas, but pajama pants? Are you wearing pants?
Yeah, pajama pants, yes.
Okay. There was another video that was played, and I'll just pull that up real quick as well. State's Exhibit number 1.
Mia Campos, killed, 7 months pregnant. Okay, I'm going to fast forward to this.
Because I want to watch the whole thing. And so I'm going to advance it here just a few more seconds. Explain to us what you're doing in this video.
I went outside and I just went to the thing and I saw police coming and I got scared. I ran into the barn and then I called my mom.
I got scared.
And then she had told me to enter my house through the back, and I entered my house and I stayed and I waited until my mom got to my house. And
so this, as we're watching this video, the person who's running around here in the yard, that's not Jesus Monroy, that's you, Rafael.
yes, that's me.
Did someone call you and tell you the police were coming?
I got a text message from the brother.
What brother?
Enrique.
Whose brother is that?
Jesus' brother.
What did that text say?
They had told me that the police are at the gate, I think, and then.
Yeah, if you guys are not familiar with the case, like I said, I did a live on this. Like, this was one of my very first lives. One of my very first lives. I think it's like the third live, so it's older. I haven't done an update on this.
But like, just like.
But I think I read some of the documents in that live.
What did you tell me?
They told you, Enrique told you to do what?
Or at least covered a lot of the
He just told me that he just notified me, and I went outside to go check, and I just got scared and I ran.
Where was Jesus?
Jesus was in my house.
And on that video, is your house the house on the left or the house on the right?
On the right, I'm pretty sure.
So when you ran,
I don't think you should have been
that house
out
that
on
we're looking
bond.
at, is that your house right there?
Sorry.
Yes.
I don't.
And Jesus was where? In that house?
Yes.
And
I
when the
don't.
police came, Jesus was right where you ran to, right?
Yes.
Okay. And you talked to him before you came into court.
Yes.
Did he show you this video?
Yes.
And he
Wow.
told you to point out that that was you?
Well, he asked me if it was me, and yes, that's me.
And you and Jesus have the same clothing?
Well, I had those pants, and he had the shorts on.
Meanwhile, Jesus' older brother testified Jesus has never been in trouble before, and if he's released, he would show up for court.
He will do, because he was always trying to get updates on the case. He was like, when do I have my next court? He was always asking so he can show up. He was conscious. He was like, when do I have the next court? Because time was just rolling by.
One of the other factors is whether Jesus is going to intimidate or influence witnesses in the case. Do you have any opinion about that?
I don't think he's going to get nowhere near witnesses.
Okay. Now, he's back in jail now, but how long was he at home with you while he was out on bond? If you can give us a rough estimate.
Since last week of August. So that's, let's say what, 6 months, 7 months?
6 or 7 months, okay.
Yeah.
During that period of time, did you ever hear Jesus attempting in any way to influence, talk to, contact the victim's family or any witness in this case?
No.
Okay. Did he ever ask you to do that?
No.
Did you ever hear him ask anybody else to do that?
No.
Wow.
One of the last factors is Jesus a flight risk, right? And we heard his comment there on the video. But give us your opinion. Is Jesus a risk of flight or fleeing the jurisdiction?
No.
During their final argument to the judge, the state was adamant.
Yeah.
Jesus is a flight risk if he's released.
I know that we just heard from Mr. Valdez who says that was him, but on state's exhibit
There's only
2,
3 more minutes of
the
this,
video,
and then
the body cam from
you-
Detective Price, we heard from Jesus Floyd, the defendant, that he did run when police came when he heard the drone. So he does acknowledge that he was the one running from the barn to the house to the other house. In fact, we heard on the camera that he said, "Oh, I thought it was a drone and I'm not going back to jail." And that he did not want to go back to jail, and that's why he ran. And he said, "I thought I was going to get arrested when I saw the lights, and I was like, oh, I ain't going back to jail." That's what he volunteered to Detective Price, Your Honor, admitting that he did run when law enforcement came and that he did not want to go back to jail. As well as we just saw him running. We heard from his own brother that they have family and friends in Texas and Mexico, and that the defendant previously resided in Mexico. So he is a flight risk, Your Honor. This defendant targeted Mia.
Flight risk.
He was a grown man, an adult. Although 19, he is legally an adult. She was 15 years old, a child. He lured her to a location in Gwinnett late at night, had sex with her, and got her pregnant. He then
Wow.
lured her out of her own home again at night and killed her, Your Honor. He is a danger to her, to witnesses, and to all children, and we're asking the court to deny bond and make sure that Mia has justice for her.
While the defense argues Jesus will stay put.
Judge Byers heard
So
all
now
of
he's
this,
locked up?
heard the state's
I know
entire
the first
presentation,
hearing
all of the
recorded.
facts that the state just presented to this court, with the exception of the additional witnesses here today regarding the flight, heard all of that and decided that my client was not a significant risk to flee the jurisdiction, not a significant risk to intimidate witnesses, not a significant risk or danger to the community, not a significant risk of committing additional felonies. And granted him bond in the amount of $50,000 on August 28th of 2024. He has bond. That bond has not been revoked. That bond is still active. He is on
It's
bond.
like a $2 million.
on those charges.
I thought
There
it
has
was
been
$2
no
million.
appropriate motion to revoke that bond that was filed by the state and notice served upon counsel. So that is not for court's consideration today. What this court is to consider is he eligible for bond on count 5, enticing a child for indecent purposes, count 6, statutory rape, count 7, child molestation, and
Wow.
2 of the counts of making false statements that were added. Those 5 charges were added by the Gwinnett County District Attorney's Office to the bill of indictment and presented to the grand jury on February 13th of 2025.
Wow.
The following day, my client was
they
arrested
paid.
on the bench warrants that were issued by the grand jury. And he has been continuously incarcerated at the Gwinnett County Detention
He
Center
should be
since that time.
incarcerated.
So the judge didn't issue her ruling at the hearing. That ended up coming at a later time. And in a stunning ruling, the judge granted Jesus Monroy a $150,000 cash bond on his new charge.
All right. Yeah, go back and watch the live. We're ending it here. Yeah. I'll see you guys tomorrow night. Thank you for being here. No Melly After Dark tonight, but we're definitely doing Melly After Dark tomorrow night. Yeah, so I hope you guys enjoyed. Hopefully you guys are members. Yeah. Mia Campos. Sad case. Yay! I'll see you guys. I plan to be live all weekend, so get ready for it. I do have to work tomorrow, but I do plan on being live tomorrow night. So I will see you guys then. Make sure you hit the like button, subscribe. Thank you to all supporters. I love you. BC Girl, glad you're back. Kay, all of you for gifting. I appreciate you. And I'll see you all on the next one. Bye.
Thank you.